Good afternoon. This is the regular scheduled meeting of the Sunshine Ordinance Task Force. Can we call the roll call?
Member Craven?
Here.
Member Craven present. Member Nee?
Here.
Member Nee present. Member Cawthon? Member Cawthon excused. Member Washburn?
Here.
Member Washburn here. Member Caneva?
Here.
Member Caneva present. Member Johnson?
Here.
Member Johnson present. Member Chu?
Here.
Member Chu present. Member Chan? Member Chan excused. Member Goldman?
Here.
Member Goldman present. Member Williams? Member Williams absent. Madam Chair, we have a quorum.
Thank you. Regarding agenda changes, I'd like to combine 8, 9, 10, and 11. Is the complainant from the Save Our Richmond Environment here? No? Members, do we have any problems with combining those items? They seem very similar to each other. Okay. Unless there's any objections, we'll go forward with that. Can you call the first item, please?
Item number 1 is the approval of minutes of April 28, 2009.
Are there any issues, any questions about the minutes? Comments? Typos? Please.
Yeah, I spotted a number of typos and other sorts of minor errors in the minutes, which I have already communicated to Mr. Rustum.
Thank you. Ms. Washburn.
I have several too, so I'll just hand them to you as I usually do.
Okay, is there a motion?
I'll make a motion to approve the minute.
Second.
Is there public comment on the minutes? Seeing none, can you call the question, please?
On the motion, Member Craven? Aye. Member Craven, aye. Member Nee?
Aye.
Member Nee, aye. Member Cawthon? Member Cawthon excused. Member Washburn?
Aye.
Member Washburn, aye. Member Caneva?
Aye.
Member Caneva, aye. Member Johnson?
Aye.
Member Johnson, aye. Member Chan? Member Chan excused. Member Goldman?
Aye.
Member Goldman, aye. Member Williams absent. Member Chu?
Aye.
Member Chu, aye. Madam Chair, we have 7 ayes.
Thank you. Can you call the second item, please?
Item number 2 is the public hearing on complaint filed by Dr. Sumchai against the Board of Supervisors for not providing public notices, agendas, and public comments opportunities during the supervisors' meeting with elected officials in Washington, D.C.
Thank you. Is Dr. Sumchai here? Chris,
We do not see her.
pardon me?
She is not in the audience.
Do you have any reason to believe she's not going to be here?
She did not indicate it.
Okay.
I did send her an email reminding her of the meeting.
Okay. If it's okay with Mr. Darby, I'd like to move on to the next item and wait for Ms. Sumchai.
To the task force members, I would like to move forward with this if we can. I can only be here until about 4:30. I remember this matter was put at the top of the agenda for this reason because Dr. Sumchai indicated her schedule was busy as well. So
Okay.
if we could, I would be more than happy to move forward with this matter.
Seeing as that, I don't think this, perhaps we can move on to the next one. Hopefully it will be resolved within 20 minutes. That would allow Mr. Darby to present before 4:30. I would suggest we take it after the next item.
Okay. We'll go quickly, I promise. Can you read number 3, please?
Item number 3 is the public hearing on complaint filed by Peter Green against the Department of Public Health for not releasing all communications, including hard copy and emails, regarding the proposed EMS regulations.
Thank you. Is Mr. Green here? Do we expect Mr. Green?
I did email him, notify him of the meeting.
Okay.
I believe the
Is the department here?
respondent-
Okay.
Good afternoon. I'm
Oh, I'm sorry. We're still trying to figure out how to, we don't usually end up with 2. Yeah, why don't we wait just a few more minutes, if you don't mind?
Sure.
The complainants put a lot of effort into these cases, so we don't want to miss that. How about number 4? Is Anonymous here, Mr. Anonymous? I do not see him either. Is Mr. Anonymous coming that we know of?
Again, I did notify him, remind him of the meeting.
Okay. Okay, is Mr. Banks here? Yes. Excellent, Mr. Banks. Let's call number 6.
Item number 6 is determination of jurisdiction on complaint filed by Raymond Banks against the SFHIV Health Services Planning Council for not providing requested documents.
Thank you.
Members, I move that we find jurisdiction on this item.
I second.
Is there any public comment on jurisdiction?
For me? Oh,
Is there any member comment on jurisdiction? Can you call the roll, please?
On jurisdiction, Member Craven. Aye. Member Craven, aye. Member Nee.
Aye.
Member Nee, aye. Member Cawthon. Member Cawthon excused. Member Washburn.
Aye.
Member Washburn, aye. Member Caneva.
Aye.
Member Caneva, aye. Member Johnson.
Aye.
Member Johnson, aye. Member Chan. Member Chan excused. Member Goldman.
Aye.
Member Goldman, aye. Member Williams. On jurisdiction for a... Jurisdiction. Member Williams, aye. Member Chu.
Aye.
Member Chu, aye. Madam Chair, we have 8 ayes.
Mr. Banks, you have 5 minutes.
okay. First of all, I'd like to get a couple of things straight with Mr. Lorente. In his memorandum, he states that certain members of the council have brought charges against Raymond Banks and have alleged that his conduct during meetings have been detrimental to the operation of the council. That's categorically false. The charges have been brought against the co-chairs of the membership committee. They were brought on 2909 for the second grievance, and I think 111008. This is the third time that he's made that allegation, so I guess he's got the information from somebody at the council. And under Sunshine, I would like to know, where did you get that information?
You have 5 minutes, and you can decide on how you want to spend that time.
I want to ask this question because I can come back on a rebuttal in regards to the other issues.
Okay, I'm not sure it changes the context or the nature of the complaint.
But yeah, I mean, he says that as a side issue not related to the complaint, Raymond Banks was fighting charges made against him by members of the council which alleged that his conduct was detrimental to the operation of the council. I mean, it's categorically false. Mm-hmm. So I would like to know where he got his information from, and I'd like to ask him publicly under the Sunshine Ordinance, please.
Mr. Lorente, if he wants to spend his 5 minutes this way.
Through the chair, I mean, my synthesis of that statement came from materials that were provided by Mr. Banks. I mean, there was a whole bunch of materials, and I just basically summarized it. That's the only source of information that I had, basically.
Okay.
That's all I have to say.
Just to let you know, I think that that this is a very sympathetic group. I don't think that we look at that and say, oh, you know.
Well, it's in public record, and it needs to be recanted because it's incorrect.
Okay. Should we go about the nature of the
Sure.
item?
We're doing 09022, which is in regards to the February 18th meeting of the special membership meeting with which Mr. Lorente talked about. And I'm requesting that the testimony of the co-chairs be public information. First of all, they're not employees. Second of all, they're not officers. Third, I don't see what kind of security risk or why this information needs to be held secret. Furthermore, they have another grievance against them, the co-chairs, based upon them saying some information and send it to the mayor. So it's false. But I would like to have that information. I would like for their next testimony, which is coming up, to be part of public record. I can't see any reason why they should not be, why they should have any kind of protection. Like I said, they're appointees, and they're not employees of the city and county of San Francisco. And they're not officers of the law, and there's not any ongoing investigation that would in some way be hampered or detrimental.
Good.
Just a sidebar. On the 14th, the council was brought in front of this committee in regards to complying with Sunshine. So I went back over to the library, and the minutes for February 18th are not there. There's no copy of them at all. There's copies of minutes for the 17th, which there was no meeting. Furthermore, I'd like to bring to the committee's attention that there seems to be a lot of drafts as far as public record and not amended minutes. I have a handout here. I'm sorry I wasn't able to get copies. Furthermore, in regards to public information, one of the charges against me in the secret letter to the mayor was that I asked for 18 requests of information and that they felt I should be removed. However, even though this committee has ruled that they're supposed to give me information, I just wanted to point out I sent a document, I believe it was the Rights and Responsibilities meeting. I sent it on 5/15/09, and I also sent you another document dated, let's see, public information with, public information. Hi, Raymond. Full agenda and meetings information as well as other handouts, if they aren't in-house, at the time of email notices are sent to the San Francisco Main Library for each council meeting and each committee meeting. I just want you to notice that memo was on 9/16/2008, and as far as that being an accurate statement, that's incorrect. The Planning Council or Council support presented at this last meeting that it was due to a change in personnel which caused the problem with the minutes. However, there has not been a change in personnel since September 2008. Also, since this is also within your jurisdiction, I'd like for you to look closely at that issue, that they haven't even followed through with the recommendations. I believe it was Ms. Washburn made on May 14, 2009.
Okay, thank you.
You're welcome.
Is there anyone, other parties of the complaint wish to present facts and evidence? Is someone from the HIV Health Services Planning Council here?
Yes, Mark Molnar, Interim Planning Council Support Director, and Steve Manley.
Steve Manley, I'm one of the co-chairs of the Planning Council.
Great. You have 5 minutes to combined.
All right, mine will be really brief, which is to respond to the basic complaint around documents not being available. Actually, all meetings are recorded, so all minutes are in the form of a recording, and we have not received a request from Raymond Banks to release that recording. When we receive it, we will give it to him.
There's really not a great deal for me to add on this particular complaint, 09022. The testimony of the co-chairs is referenced in the minutes of the meeting. We normally do not document every word that is said in minutes. They're a summary, and the recordings are a matter of public record, and anyone can request copies at any time, and so far Mr. Banks has not requested a copy.
Is that it? Thank you. Are there other parties of the city who would wish to respond? Seeing none, the matters of the task force for discussion and questions. Any?
Yes, to the respondents, could one of you approach the microphone, please? Okay, you mentioned, sir, that the meeting is recorded. Audio recorded or video recorded?
Audio.
Audio. So if a deaf person wanted to obtain the minutes of your meeting, what would he do? You have no written minutes?
No, we would have to transcribe them for that individual requesting, which we would, of course.
Thank you.
Sure.
So just to clarify, the minutes that were provided show that, at least the copies that we have in our packet, the draft minutes, I believe they were, of the meeting in question, seem to indicate that the committee interviewed 3 co-chairs, and it just says when the interview started and when the interview ended. Was that how the final minutes were approved? Or was there additional information provided?
I'm not sure about when the final minutes were approved. I'm not sure if that committee has had a chance to actually approve those minutes.
All right, but
Raymond or Chris would know.
Mr. Banks, do you want to respond?
Yes, I feel awkward in this position, but yeah, they were. And I gave you the draft. That's my bad. I should have gave you the amended minutes, but the amended minutes said the identically same thing as the draft minutes, pretty much, in regards to the co-chair testimony.
Okay,
and furthermore,
that's okay. That's the question. And so, but if any member of the public, because it looked like there was some discussion about closing this hearing.
There was discussion, but it was not a closed.
It was not a closed in the end, and so the public were allowed to be present, and if someone requested copies of those tapes, they would be produced?
Absolutely.
Okay. Thank you for clarifying that.
Was the meeting agendized as a closed meeting?
I think it was only at the discussion state that it was considered to be a closed meeting. And then after researching Sunshine and other council bylaws, it was determined that it was there was no way it could be a closed meeting.
Oh, thank you. I'm glad that you came to that conclusion.
Yes.
Any other questions? We now have an opportunity for the respondent and the complainant to present any clarification or rebuttal. We start with the city, actually. I know it's a strange process, but we follow it every single time. Does anyone from the HOA Council have anything additional to add?
No, that's pretty much it.
Mr. Banks? You have 3 minutes.
If you look at the memorandum from Greg Zauberboff, they tried to prevent me from even attending the meeting. It was closed. I'm sorry I didn't bring the recording of the meeting in discussion, but in the first 3 minutes they bandy about whether or not the information should be, whether this is a closed or open meeting. So that's incorrect. As far as my knowledge, and the library seems to confirm that, is the fact that the minutes for 218 have never been posted. The agenda has never been posted. So how could they have noticed the meeting publicly with the library as 3 days before? I've looked at some of the other minutes, and they have been complying in general with the 3-day rule. However, there's just a complete blank. I brought copies of it, but I only brought one copy. But anyway, it states clearly that it was on 2/17/08, which there was no meeting. 2/17/09, I'm sorry. 2/17/09, there wasn't any meeting. So what I pulled from the library, I have the printout here from the library, and I'd like to enter that as an exhibit. It's February 17th. I'm sorry I didn't bring multiple copies, but it's at the bottom. It says February 17th, 2009. However, as everybody knows, if you look at the meeting, if you look at the bottom of the...
Oh, yeah.
And so it says draft. However, the irony of the whole process, if there was a draft, there was no meeting on 2/17/09. It was canceled. So what is the draft? So I just feel that whether I want a recording or not, if someone anonymously wants to review the minutes or whatever for whatever reason, it kind of came to Mr. Anonymous. Why do they have to go to the council to get a recording when they can just go to the library and in their own privacy or look it up on the internet? They say, well, we supplied you. I didn't ask for a recording. Well, true. I didn't make it. I made my own recordings in regards to those 2 dates because they had problems with the tape recorder, batteries running out, different things like that. I just really hope that you, for the upcoming meeting, decide here to make sure that the testimony, there should be some sort of synopsis of what the minutes were. And if I didn't bring a copy of my testimony, but I was more than happy to note in the minutes, during the meeting, that I wanted my testimony to be made public. I think that why would you not want your testimony to be made public unless you have something to hide? And I know that's kind of a...
Thank you, Mr. Banks. The matters of the task force for motion and deliberation. So we have two issues here, right? Whether it could be a closed meeting, and that's become not an issue, and whether the minutes actually reflect as accurately as we need for the Sunshine Ordinance. We can't discuss the notice issue, with the potential notice issue. Am I summing this up correctly?
For me, I think it revolves around the minutes. That's the only thing that we can decide upon. But
yeah, the Sunshine Task Force, Sunshine Ordinance is not that specific in what needs to be in the minutes, right? It's
cited it in 6716, what's required, and it doesn't require verbatim recording of testimony. It has to do as to what was identified as to who spoke and what was the position and what was the vote taken. This task force has decided to go beyond that, but that's on its own.
Right. Does anyone have a motion?
I have a suggestion for one of the respondents, if possible, seeing as the minutes are not, the minutes have been filed. Would it be possible to do amended minutes that included a one-sentence summary, if possible, of each speaker's position on the matter? I do note that the rest of the minutes do seem to have some substance to each agenda item, whereas this one does not. And I don't know if that was intentional or not. But a way to obviate this complaint would be to do amended minutes, to include in those minutes, a short summary, one sentence, two sentence of each speaker's comments that were taken in what was apparently an open session. And would you be able or willing to do that?
Of course, we would definitely be able to do that, but I do want to mention that it would be, there was a reason why it was so short. This was in response to a removal request from Mr. Banks, and so the questions there were many, both on the fly and questions that were noted in advance, and they were having to do with the co-chair's assessment of Mr. Banks's character on the council and his various actions, and so we just deemed that to be just really sensitive in terms of that, and so that's why the synopsis is so brief. But yes, we can certainly have the admin support person listen to the recording. It will be difficult. There's probably about a half dozen to a dozen questions per person as the membership committee thought of them. But yes, of course.
Right, so it's really an issue of, how do you summarize a half-hour series of questions into minute form, which I don't think you're required to do. But if you're willing to do it, it would obviate this complaint. So I would just leave that out
Willing
there.
to do it, absolutely.
I agree. These suggestions aside, I agree with them. I just don't see a violation here that we can actually rule on. So I would move that we find no violation on this.
I second that.
If there's no other comments, we'll take we'll take public comment on this item. Is there any public comment on this item? Seeing none, can we call the question, please?
On motion to find no violation, Member Craven. Member Craven, aye. Member Nee.
Aye.
Member Nee, aye. Member Cawthon. Member Cawthon excused. Member Washburn.
Aye.
Member Washburn, aye. Member Caneva.
Aye.
Member Caneva, aye. Member Johnson.
Aye.
Member Johnson, aye. Member Chan. Member Chan excused. Member Goldman.
Aye.
Member Goldman, aye. Member Williams. Member Williams, no. Member Chu.
Aye.
Member Chu, aye. Madam Chair, there's 7 ayes and 1 no.
Thank you. So, Mr. Banks, we found no violation on this item, although clearly there were still some concerns with the minutes, and we'd love to see them a little bit more detailed. Thank you. So we'll move back to number 2, which has already been called. Dr. Soon-Chai.
I thought I had 2 complaints down here. I'm missing twice.
One was for jurisdiction of your complaint, and one was your complaint.
The jurisdiction was that thing we went through before you started talking.
Mm-hmm.
It was just this procedural thing that we have to do to accept the issue, which we don't have to with Dr. Soon-Chai. You have 5 minutes.
I won't take 5 minutes. I will be very, very brief. I believe that I have provided you with irrefutable documentation that there were violations in the Sunshine Act that occurred when the 6-member majority of the Board of Supervisors went to Washington, D.C. In March.
Thank you. Are there other parties of complaint wishing to present facts and evidence? Seeing none, is the city prepared? Mr. Darby, you have 5 minutes.
Yes, task force members, Frank Darby, Records and Information Manager for the Office of the Clerk of the Board of Supervisors. With regard to this complaint, I don't have much to say other than what was already mentioned at the first hearing. I did provide in your packet a copy of the agenda for the Washington, D.C. trip, which shows that there was agenda items from Sunday through Wednesday, March 8th through 11th. I've also included a copy of the letter that Dr. Soon-Chai had mentioned in her note to the task force from Carol Procenti, I believe her name is, as well as the minutes from the Budget and Finance Committee. Basically, I just wanted to indicate that the majority of the Board of Supervisors did attend a conference in Washington, D.C. That conference started on Sunday the 8th and ended on Wednesday the 11th. And at the last hearing, Dr. Samchai referred to a wrap-up session, which she felt was a violation. That wrap-up session is part of the actual conference, and there was some material associated with that wrap-up that has been provided. The reason why I provided also the minutes of the Board of Supervisors Budget and Finance Committee is to show that all the supervisors who initially went on that trip were not on that last day. In fact, Carmen Chu did not stay for that Wednesday meeting at all, so she was back in here for the Budget and Finance Committee meeting. So basically what I'm saying is that there was no violation of the ordinance of the Brown Act. I'm asking that this task force dismiss this complaint or find no violation. Thank you.
Thank you. Are there other parties of the city who wish to respond? Seeing none, the matters of the task force for discussion and questions.
I actually find this a very complex issue. Part of the reason I find it a complex issue is that it looks like there were two conferences going on. There was a regional transportation conference, and then there was a lobbying trip. Is that a meeting organized to address a topic of local community concern open to the public? It certainly is a meeting organized to address a topic of local community concern, which is securing stimulus money for the city and county of San Francisco. So it seems to me there's something more than a conference going on, and I do think this is a very interesting issue, and I think it's one that hasn't been fully briefed, and in my view hasn't been fully explored in litigation or court opinions under the Brown Act or under the Sunshine Ordinance regarding, what can elected members of a local body do when basically lobbying the federal government for funds. I think going to the conference themselves is fine. I think probably going on the trip is fine because there's all sorts of Chamber of Commerce trips to sister cities like, Japan and, South America and, France that our elected officials go on to foster, usually sponsored by the Chamber of Commerce and sponsored with the purpose of benefiting each of those localities' economies, really. So I think it's an interesting issue. But my bottom line is Dr. Samchai says she's shown us irrefutable proof of a violation. Dr. Samchai, I don't see that. You've submitted 500 pages of documents, agendas, and commentary, but nowhere do we have evidence that a majority of the Board of Supervisors were in any place at one time, whether or not they were talking about a matter within the jurisdiction of the San Francisco, within the jurisdiction of the Board of Supervisors. I think Dr. Samchai's main concern is the transfer of, under federal law, of Treasure Island and perhaps Hunters Point Shipyard to a redevelopment agency, which is a separate political entity than the Board of Supervisors. The Board of Supervisors plays a policy role in endorsing some redevelopment plans, I believe. But in terms of the transfer itself, I don't even think that that is necessarily a matter within their jurisdiction. It's a matter that's negotiated with the mayor's office, is my understanding, with the feds, because it's a transfer that happens under federal law. So even if we drill down to the narrow issue that Dr. Samchai is most concerned by her own admission in her own letter, I don't see that there was, even if six members of the Board of Supervisors met with Senator Feinstein or Congresswoman Pelosi, I don't even see that as a violation of the Brown Act or the Sunshine Ordinance. So that's where I am. I do think the greater issue is really an interesting issue that, as I said, hasn't been developed. But even if we accept some of the facts as alleged, I still don't see a violation at base. And I'm also troubled by some of the supervisor's failures to produce records, but that's not in the complaint. The complaint deals with this other issue about the unnoticed meetings. So on that issue, which is what's before us, I simply don't see a violation.
I agree with Member Craven on a number of issues, especially obtaining to what interest the Board of Supervisors played in this, and if it was financial interests having to do with lobbying our city, but you said that not all members were present at the same time, but within the Good Government Code Book it says that a policy body not present in one place at one time can still be an unlawful meeting.
Right. If there are efforts to reach consensus about an issue within their jurisdiction. So it's really, you're right, maybe I spoke too broadly. I mean, the allegation was that they had meetings to reach a consensus within their jurisdiction. I don't see any evidence that there was an effort to discuss something within their jurisdiction.
For me, I mean, I've looked over this a few times, and the problem that I have with it is I can easily imagine that they're discussing things in their jurisdiction. However, I don't see anything in here that's telling me that they are. And for me, I hate to use the cliche of the smoking gun, but I just don't see anything here that's telling me that they're doing something that they shouldn't be doing. I can easily imagine it, like anybody else, but that's not enough for me to find a violation.
I'd like to ask Dr. Somchai what she believes is the most telling evidence of all the material she's provided us. If you could point us to what you think is a plausible...
The meeting with Senator Feinstein that was referenced by the president of the Chamber of Commerce in the Examiner and is documented in the information that was provided by the mayor's office, in which, again, the topic of the transfer this year of Treasure Island, which was discussed. That was clearly a matter that was not on the agenda either of City Trip 2009 or the Municipal Transportation Agency, and there's clear documentation. I believe that all 6 members of the Board of Supervisors attended that meeting. It was not a noticed meeting. The public was not invited to the meeting, and I have to say that I really am very, very disappointed if with all the information that you have of meetings that occurred outside of the agenda, including Eric Marr's email in which he references a meeting with labor, that you don't see that there were opportunities and that the public was not included in those opportunities for discussion.
I would just like to know, how were there 6 supervisors chosen to go by the Chamber of Commerce? And was the public notified that the Board of Supervisors regular meeting was going to be canceled?
Frank
has that.
Yeah, Frank, if you want to address that, but we talked about that actually, I think last time. It was definitely noticed. We got that. There's no question about that. And how were they picked?
In your packet, beginning on page 36 to 39, are cancellation notices that was mentioned last meeting, whether the meetings were noticed that there were cancellations. And so those cancellations are in your packet, pages 36 to 39. As to how it was determined as to which supervisors would go on that trip, I don't have the answer to that question. I would have to check with the president of the board. I know a notice information went out to the president of the board, President David Chu, but how he went about determining which of the 11 supervisors would actually go on that trip, I'm not certain.
Yes, I see, Mr. Darwood, that the notice says it was the meeting was going to be canceled, but it's not saying the reason why it's going to be canceled. And I think the public had the right to know why the meeting was going to be canceled. Just as if, if I don't show up or somebody show up, we should have a reason. And I don't see any reason being given here.
Well, Well, no, there's no reason to submit it, and under the ordinance, there was no specific indication in the ordinance that stated that there needed to be a specific reason, but that notice of the cancellation needed to be made, and a notice was made the week prior to the cancellation. On one of the hearings that was canceled, the Land Use and Economic Development Committee meeting, the majority of those members were in Washington, D.C. The same is true for the full board meeting on March 10th.
Mm-hmm.
But the cancellation notice did not indicate that the meeting was canceled because they were in Washington, D.C. No, did not.
And for what reason they were in Washington, D.C.?
Well, for this conference.
Yeah, I know for the
Right.
conference, but,
Right, but the notice didn't indicate that they were in Washington, D.C. attending the conference. Our normal notices, which has always gone out, just indicate that the meeting was canceled, and that's how it was posted.
But to me, when our boards of supervisors that we've elected, I would like to know where they're going, what they're going for, and what they're talking about. And that's the only thing, Barney. It looks like it's two issues here. You could put out one thing and said that we're going here for a conference and have a sidebar. You know that happens, and and I'm concerned about that they went for one thing, and to lobby for us for finances was great, but it appears that it's something else deeper than this in here.
Thank you. So, Ernie, can 6 members of the Board of Supervisors sit down with Dianne Feinstein?
Well, assuming that you have evidence that they met with Feinstein, the question is, did they talk about matters that were within the subject matter jurisdiction of their powers as supervisors for the benefit of the city? They can meet with Supervisor Feinstein and talk about the wonderful weather they have in Washington, D.C., or they can talk about other business that isn't directly related to the city. The question is...
Right.
Can they say, we want all sorts of stimulus money for the MTA?
I think if it gets into business of the city, which is one of the departments, I think that may be troublesome. I think that could...
Well, I mean, that's exactly the question. I mean, I think the purpose of meeting with Senator Feinstein, assuming all 6 were there, were to seek stimulus funds for housing, MTA. I mean, that's pretty obvious what the trip was for. So I agree, we don't have proof that all 6 members were there, so that's an issue. But I mean, this is, I think, the really interesting question that I started out before that I think hasn't been explored that much.
I think that's really a really new area. You're right. My sense is that if they were talking about city business, that it could be considered a meeting.
Okay, well, what about the conveyance of Treasure Island or the Hunter's Naval Shipyard, which, as I understand it, is something controlled by federal law,
Right.
as to which the Board of Supervisors may have a small, as I understand it, advisory role as to how that land, once transferred, is then used, but don't necessarily have the power to affect the transfer.
Right.
So-
Right. It's another entity which is not a city entity.
It's a redevelopment agency.
Right. Right. Then, so they're lobbying for the benefit of a third-party interest. The question is that city business? It's a very interesting question. I don't know.
Mr. Lorente, does that still hold a conflict of interest with a private entity?
Well, it's not really a private entity. It's a public entity, but it's not a city entity. Redevelopment agency is not a private entity.
That still be a conflict of interest?
I don't think it's a city.
No, it's not a city entity.
No, it's not. It's
a state.
It's a government entity, but not a city entity. Redevelopment.
I mean, if there's an economic interest in how it could affect, that holds a conflict of interest.
Well, there's a conflict of interest.
Only if
If it inures to the benefit of the representative, I mean, if a person is lobbying for, and they will attain a direct benefit from it, and they have a governmental responsibility, then I think that that's where the typical conflict of interest due to financial concerns are involved. This is a little different. It's kind of a step removed.
Right. If I'm on the MTA and I go to Washington, D.C. and say we need federal stimulus money because it's going to be great for our transportation, that's not a conflict of interest. If I go to Washington, D.C., and I'm on the MTA, and I go to Washington, D.C., and I say, I think you should give it to to A Plus Road Construction. It so happens that my nephew owns A Plus Road Construction. That is a conflict of interest.
Yeah. That goes to a personal interest, usually tied into the person who's a government representative.
Frank, do we know if all 6 were at the meeting with Dianne Feinstein about the Treasure Island?
On page 58 of your packet, there is a budget and finance meeting information portion of just page 1 of the minutes, which shows that Carmen Chu, Supervisor Carmen Chu, who had attended the conference, was not at that meeting on the day that the other supervisors met with Supervisor Feinstein and others. Therefore, there was not a majority of the board at that meeting on March 11. Only 5. If all 5 did attend, it was only 5 and not 6. So therefore, there was not a majority at that meeting.
Okay. Well, let's move forward a little bit. We'll come back to discussion. This is an opportunity for the respondent and the complainant to present any kind of clarification or rebuttal. We start with the city. Do you have anything additional to say, Mr. Darby? Thank you. Dr. Sumchai, if you'd like, you could have another 3 minutes.
The majority of the Board of Supervisors, 6 members, traveled to Washington, D.C. They attended 2 simultaneous conferences. By March the 9th, it appears that all 6 members of the Board of Supervisors were recruited. It appears that they were recruited by Supervisor Bevan Dufty. It is not clear how the 6 members were chosen. In addition to the meetings that were associated with the 2 conferences, there were additional meetings that were organized once the supervisors were in Washington, D.C., and this is documented in an email sent by the Director of Communications by the San Francisco Chamber of Commerce, which sponsored the conference. March 11th was the final day of the conference, and there was an overview session, and Supervisor Carmen Chu was not present for the overview session, but my understanding is that all 6 supervisors were present for the meeting with Senator Feinstein. I do not believe that the meeting with Senator Feinstein occurred on March the 11th. There are issues of ethical violations with regard to the underestimation of the costs of the gift of the conference that were documented by some of the supervisors. The San Francisco Chamber estimates that the costs of airfare, accommodations, travel, and meals exceeded $4,500. I am not in possession of any documentation from any of the supervisors in which that amount was documented as a gift. I think that Supervisor Chu, the president of the board, documents an amount of $400 as his gift, and this is a matter that the Ethics Commission needs to probe. Again, I feel very, very confident that there were violations of the Sunshine Act. Commissioner Craven, you should be aware that the Board of Supervisors has to approve the transfer of federal lands into the possession of the City and County of San Francisco. I attended the board hearings for the transfer of Parcel A. So the redevelopment agency is the receiving state agency, but the Board of Supervisors has to approve that transfer of land into the possession of the City and County of San Francisco. And I do believe that this was a driving issue that brought the need for 6 supervisors to attend the conference forward. I will accept your decision on this matter. Again, I think that the evidence is overwhelming. I know that you are under pressure I know that this Board of Supervisors is a big body. I think that this is an opportunity for you to demonstrate, your power and your advocacy on the part of the public and the Sunshine Ordinance. And I want you to recognize that there were violations of the Sunshine Ordinance, the ethics laws, and the Brown Act that occurred during this trip. Thank you.
Do we have a motion? Do we want to deliberate some more? Any other questions? I think we're in this middle ground. I don't think anything willful happened. I don't think anything, we know a lot about what happened there. There's probably a lot we don't know, but it doesn't feel like there's anything willful. And certainly it doesn't, for anyone that watches the board, doesn't seem like anything, that 6 has come back with any kind of alliance that's, that's like achieving anything at the board. But to say that they, that really didn't happen over all those days, those 6 were not together discussing matters of the city. It's hard to say that. So
that's the problem that I have with this too. Is something in my gut doesn't sit right. I just can't find how to find a violation on something that I feel in my gut. It doesn't sit right with me. I just don't see how to. I don't know how to articulate a violation on this that is meaningful and that I'd feel comfortable voting on.
Either Frank or the city attorney, is there a policy as far as an advisory role when the board's looking to travel together about whether there's an attempt to limit to 5 members as opposed to having a majority as a general policy? It seems like a lot of ease could have been made, if it's just generally we try to not have a majority travel together when possible. Is that something that people consider and aim for?
I think that this body does provide information and advice to other entities in the city to try to make sure that they comply with the Sunshine Ordinance, the Brown Act, and the Public Records Act. That's part of the duties of this task force. Did this body give an earlier advisory opinion about how to do it? No. But is it something that they can do now that we have this issue in front of them? Yes. They could say, this has come to our attention, and although should this be your decision that we don't find enough for a violation, we do suggest and advise that as a matter of policy in the future, that if there's any trips or conferences that deal with the federal government and funding agencies, that you limit it to less than a majority, just so this particular issue does not become a problem, because that's one possibility.
My only comment would be as follows. I think as Member Johnson, I believe, pointed out, the fact that they traveled together, a majority traveled together, is perhaps more problematic because it raises the opportunity for collective deliberation. And the issue is collective deliberation or decision-making, conveying the views to each other of how I'm going to vote on something that's within my jurisdiction. That's the problem. Or how I'm going to address this issue that's within our jurisdiction. Here's what I'm going to do. How about you? That doesn't necessarily mean that they have to travel together to do so. You could have a conference call. You could send an email. All of those methods of basically conveying your beliefs and reaching consensus on an issue within your jurisdiction is what the Brown Act seeks to prohibit. Maybe it is good policy to say, to minimize that, we recommend that you don't all travel. A majority does not travel to a particular conference, but it does say a majority attending a conference is one of the exceptions to what a meeting is. So I'm not so sure that would be helpful. The other thing I would note is that the complaint here is not that they reached a decision, that the Board of Supervisors, a majority of the Board of Supervisors reached a decision on something within their jurisdiction, or that even they were conveying their position on what they might vote on. It's that they had a meeting in D.C. that was not noticed, did not provide for agenda, and there was no public comment opportunity. And as far as Mr. Darby has said, the evidence shows that there weren't a majority of people meeting with Senator Feinstein. Dr. Sumchai counters that assertion. I don't know if any of us have definitive proof one way or the other, but that's the nature of the complaint. And I agree that my gut says there's something wrong, there's something difficult about this question about when you have people lobbying on behalf of the city, and it happens to be a majority of the Board of Supervisors going to lobby. It's problematic, but again, I don't think there's been a demonstration of a violation on the nature of the complaint before us. With respect to the potential ethics violations for failure to report the gift, those really aren't before us. If those existed, please do bring them to the Ethics Commission. That's a serious, significant issue which should be followed up on, and I hope Dr. Sumchai will, and I appreciate her bringing this issue to us in the first instance because it made me really think about this issue of lobbying and how do you do that if you're an elected official. So anyway, I just wanted to bring people's attention back to the complaint that's in our packet at page 27.
I would just like to, I just got my package yesterday, so late yesterday, my mailman. When the supervisors came back and do an introduction or any time, did they present this to the public on SF.gov? I look at TV all the time. I've heard nothing about this trip to D.C.
Not that I've heard of, but yes, Mr. Darby.
I haven't heard anything about this trip. When they make introductions or when they're talking about something, I have heard no supervisor that went there talk about this trip.
Is Frank here? Still, sorry, I can't see you. Because wasn't there actually a presentation? Wasn't it somebody required that the board do some sort of announcement post the trip at the board meeting following? I believe I caught that on TV, but I'm not certain.
I don't recall.
Okay. I thought that I did see that. I'm like 90% certain that when they at the meeting where they decided to not hold the next meeting, there was some discussion amongst the supervisors about it, and I think Alioto Pierre was the one who said, "Well, there should be a report back." I believe it was fairly brief, but that was at the following board meeting.
Was there a presentation made?
Brief overview of what happened, not. Oh, okay, so you. Okay. I'm not certain then.
Okay, any other comments? Awesome.
I feel the same way as the other members who have spoken about this matter. There's no proof that the six of them met with Senator Feinstein about the transfer of these bases, but the absence of proof doesn't mean that it didn't happen. And so, that kind of sticks in my craw a bit, but I don't think there's anything we can do to act on that. But I do think that I like Ernie's suggestion that we urge the Board of Supervisors to adopt a policy where the majority of them don't travel in circumstances where they could be conducting city business away from the residents of San Francisco. I don't know how to do that in such a way they'll take notice, but you might be able to help us figure that out.
I think it comes back to the old write a letter.
And just to clarify, I think the letter should be specific. I think going to a conference that's open to the public is a specific exemption of what, or is a specific definition of not a meeting. It's really when members of the Board of Supervisors are lobbying specific individuals or specific agencies in a manner that isn't an open meeting, right, or an open conference, I should say. That's really where the problem is. So if we do write a letter, it should be directed at, refraining from a majority of the members of the public having, non-public meetings to discuss, matters within their jurisdiction.
Okay, if there's no...
In the meantime, I have yet to see a violation, so I move that we find no violation.
Can I amend that to say we find no violation and write a letter?
No violation.
And recommend that we write a letter to the Board of Supervisors suggesting making good policy decisions?
If we get a second.
If we get a second.
Second.
There we go.
Thank you. Is there any public comment on this item? Please.
Yeah, I didn't get a chance before. I just want to thank you guys for being here. You've helped me a lot in some other things, and so I didn't want to misappropriate this time, but thank you.
Thank you. Is there any other additional public comment? Seeing none, if members don't have any other questions, we can call the question.
On the motion to find no violation but write a letter of caution, Member Craven.
Pass.
Member Craven, pass. Member Nee.
Aye.
Member Nee, aye. Member Cawthon. Member Cawthon, excuse. Member Washburn.
Aye.
Member Washburn, aye. Member Canepa.
Aye.
Member Canepa, aye. Member Johnson.
Aye.
Member Johnson, aye. Member Chan. Member Chan excused. Member Goldman.
Aye.
Member Goldman, aye. Member Williams.
No.
Member Williams, no. Member Craven.
Aye.
Member Craven, aye. Member Chu.
Aye.
Madam Chair, there's 7 ayes and 1 no.
Thank you. Is Mr. Green here? Is someone from the Department of Public Health here? I think it's time to get going with number 3, unless there's any concerns.
All 3?
Can you call number 3, please?
Item number 3 is a public hearing on complaint filed by Peter Green against the Department of Public Health for not releasing all communications, including hard copy and emails regarding the proposed EMS regulations.
Hi.
Good
5
afternoon,
minutes.
members of the task force. I'm Dr. John Brown.
Just a moment, please. Yes.
In the complainant's absence, I would suggest respectfully that you ask first, before hearing from the respondent, if there is anybody in the audience to present facts and evidence in support of the complainant.
Sure. Is there anyone in the audience who would like to present facts and evidence in support of the complainant? Seeing none. You have 5 minutes.
I'm Dr. John Brown, the medical director of the San Francisco EMS agency, and this is the first time I've been before the task force. I think maybe it would be helpful if I just present a brief overview and then our response to date to Mr. Green's requests. We're in the process of redesigning our EMS system as required by the state EMS authority. EMS is a shared regulation between the state and the local EMS agency. San Francisco has a local EMS agency. And in the process of doing this, we're going to have to change our ambulance ordinance, which is our local law concerning how to govern the ambulance system. In the process of this, we're going to go before the Health Commission and the Board of Supervisors. But in preparation for that, we have developed draft documents of the ambulance ordinance and brought it to our constituents for review. And what we do for our normal policy process for developing policies governing the ambulance system is to have a public develop the proposed changes in our policies within our staff, put it out for public comment, and have it reviewed by the EMS Advisory Committee, which has members from all of the EMS constituencies, the hospitals, ambulance companies, professional organizations, member of the public, and so forth, and then send it to me as the medical director for review and final approval by the Director of Health. This, however, is a local ordinance, so we'll go through the Board of Supervisors and via the Health Commission. But we wanted to add some additional time and ability for our constituents to review the materials. So we developed a draft, posted it on our website, had a special meeting of our EMS Advisory Committee for review and for more public comment, and now we're in the process of developing a second draft, which will then go to the Health Commission. There'll be a public hearing then, and then we'll go on to the Board of Supervisors for another public hearing. So Mr. Green requested information on the ordinance development. So we sent him about 21 documents, which were all of our worksheets for developing the fee section of the ordinance, and then our drafts. And then he came back with a reply that there were no emails that were included in this. There were some emails primarily back and forth between the city attorney that's working with us on this, because this is our first change in the ambulance ordinance since it was originally passed in the 1970s. So quite a bit has changed. So we had some communications back and forth with the city attorney who's advising us on this. So I then went back and looked again at my email system to be careful that it wasn't the first request. The documents I pulled and went through all of our emails that had to do with my email box. This time I went back and looked at all of our staff as well. I did find 6 emails that did not involve the city attorney, so I also provided those to Mr. Green with a message that I think is part of the packet saying, please, if there's specific information or some specific item that you want, we'd be glad to provide it for you. We are trying to make this a very open and transparent process. I think that in order to get the ordinance passed, it's only going to benefit us if we can work out any areas where we have disagreements and so forth and come to as close a consensus as possible before bringing it to the Board of Supervisors. So again, I'm happy to provide additional materials. I'm just not sure what additional materials it is that would be helpful in this case. Thank you.
Thank you. Are there other parties of the city who wish to respond? Seeing none, the matter is the task force for discussion and questions.
Just to confirm, Dr. Brown, the only thing that has been withheld are emails that were sent to or received from the city attorney's office with respect to the development of this new regulation. Is that accurate?
That's correct.
Every other document that was requested has been produced?
That's correct.
Thank you. Are there any other questions or discussion points? As part of our process, you now have an additional 3 minutes, if you'd like it, to rebut anything that happened. Okay. Thank you. Sorry, I didn't mean to laugh. It's part of the process. Matters of the task force for motion and deliberation.
From what I've read and what I've seen here, I think that Mr. What's his name? Green again. Mr. Green got what he needed. I think it's probably why he's not here today. But that's just my assumption. I don't mean to project. So I move we find no violation.
Is there a second?
There is a second right here.
Thank you.
I think what we have here is someone who thinks that there's more, right? They think that there's going to be something, and they request, and they get everything that they can, and it's not what they wanted. I think that sometimes that happens. I think that may be what's happening here. That, too, is pure conjecture. But at any rate, I don't see a violation here.
And just to confirm with Dr. Brown, in the future when you have requests, will you initially check the email? Because that is really primarily the source of communication in departments these days. And it seemed like it was an afterthought that you relied on the requester to follow up with you. And I just want your statement on the record that when you get public requests or Public Records Act requests for documents dealing with a specific issue, that you will initially, as part of your burden in responding, search emails as well as other repositories of information.
Absolutely, I will. And just to clarify, I did do that for my own email, but I will also search for any emails from our staff as well.
Right, because you're not the only one dealing with these issues, correct?
Understood.
All right, so you'll check all, I believe what the law requires is that you check basically check with individuals who may or are likely to have information on a particular topic, and you will do that in the future.
Yes, I will.
Thank you. Is there any public comment on this item? Seeing none, if there's no other comments, we can take a vote.
On finding no violation, Member Craven. Member Craven, aye. Member Nee.
Aye.
Member Nee, aye. Member Cawthon. Member Cawthon, excuse. Member Washburn.
Aye.
Member Washburn, aye. Member Knebber.
Aye.
Member Knebber, aye. Member Johnson.
Aye.
Member Johnson, aye. Member Chan. Member Chan, excuse. Member Goldman.
Aye.
Member Goldman, aye. Member Williams. Aye. Member Williams, aye. Member Chu.
Aye.
Member Chu, aye. Madam Chair, there are 8 ayes.
Thank you. It is after 5 o'clock, and that means it's opportunity for general public comment. Is there anyone from the public that would like to comment generally on any matters in front of the task force or within our jurisdiction? Nothing?
One person.
That's you?
Yeah, that would. I mean, how much time do I have?
5 minutes, I think. 5? 3 minutes. Sorry.
I was hoping for 5. Thank you.
This committee does not issue orders of determination. That's for the full task force to do. If there is perceived continued violation, Mr. Witt, then we will take that back to the full task force for possible referral to the Ethics Commission, which is empowered to take some enforcement actions.
That tape was March 10th of 2004. That was 5 years ago. I responded 3 days later to that comment with a new charge. I never got a response from this committee, or from the Compliance Committee to that. And I don't believe it was sent to the full task force. My next complaint, that is, in April of 2008. I've filed 14 complaints against the Taxi Commission. The Sunshine Task Force in June found that the Taxi Commission had indeed again violated 67.15 and 67.16, yet no referral to the Ethics Commission. In August of 2008, another complaint filed, another violation found by this Committee, 67.16, and still no referral to the Ethics Commission. Now, last February 20th, I submitted Exhibits A through H, which includes a minimum of 30 additional violations by the Taxi Commission, labeled, and my brief labeled Exhibit I. In March, I received an email that starts out, see attached. Well, I will read that to you. It starts out, your complaint against the Sunshine Ordinance Task Force, if such were the case. It ends by saying, I strongly urge you to take the matters into the Ethical Commission, which has the authority to investigate complaints filed against the task force. I filed no complaints against this task force, and I have yet to have a response about my 30 complaints. I noticed on your things today several complaints about timeliness, not providing requested information, matters forwarded to the Ethics Commission, matters of willful noncompliance to the task force. In other words, people didn't comply, and you referred these to the Ethics Committee. I'm wondering, what is your job? Your sole purpose? The Taxi Commission has not responded to my requests for information when they existed. Yet people that work for them still are embedded in this government. And that would be specifically Jordan Thigpen and Heidi Macham.
Thank you.
Thank you.
Is there any additional general public comment? Seeing none, can you call number 4, please?
Item number 4 is the determinant of jurisdiction on complaint filed by Anonymous against the MTA for violation of public records access.
Members, I move that we find jurisdiction on this item.
I second that.
Is there any member comment on jurisdiction? Is there any public comment on jurisdiction? Can you call the question, please?
On jurisdiction, Member Craven. Aye. Member Craven, aye. Member Nee.
Aye.
Member Nee, aye. Member Cawthon. Member Cawthon excused. Member Washburn.
Aye.
Member Washburn, aye. Member Caneva.
Aye.
Member Caneva, aye. Member Johnson.
Aye.
Member Johnson, aye. Member Chan. Member Chan excused. Member Goldman.
Aye.
Member Goldman, aye. Member Williams. Member Williams, aye. Member Chu.
Aye.
Member Chair, Madam Chair, there are 8 ayes.
Thank you. Is Mr. Anonymous here? Hi. You have 5 minutes.
I should have put my name in Barry Toronto. I was here about 3 months ago. Another issue involving the MTA. First, want to say you have a binder. Great. We can look at it during the meeting. It's very helpful. It helped me today. Also, on your website, I got an email saying select the number of your item and all your background documents are there. They're all there. It's great. Only my items. No, not the item before, not the one after. My items. And that is the difference between your body and the MTA. Huge difference. First, I want to say I went to a workshop doing taxi issues on the 18th of March, and I went to the MTA meeting the day before, and there was no packet there to look at. So I wanted to see the budget report that was presented that day, and I asked the receptionist for that information that was presented, because in her document to you, she said I was unclear of my original request. I said the budget report presented at yesterday's board meeting. I said that. I am sure. So she is calling me a liar. 2, she's not a substitute person at that desk. Every time I go up there to the 7th floor, either to attend a meeting or see somebody about a subject, she's always there. Always. So I don't know why they call her a substitute. She knows what a board packet looks like. 2, they hide the board packets. They put them in drawers. The Taxi Commission, mainly my main issue is to involve with Taxi Commission and parking and traffic issues, because those are the 2 commissions I used to attend. The buses, not that important. I lived in the city for 5 years, but I moved back to San Rafael. The buses are not important to me. I more care about those 2 issues. So so the thing is, though, is that I asked her, and she acted very uncertain about what to give me. Now, she could have handed me the board packet, because at the Taxi Commission, you have them right there on the counter. Jamie Politz, who's here, used to work at Taxi Commission, she knows. They're right there on the counter. You just look at them, you say, I'm looking at them, and that's it. No, they hide them. They put them away in drawers. She could, Roberta, who identified in her letter to you, could have just handed it to me and said, see if this is what you want. And if not, I'll check with someone else. No, she had to make a series of phone calls to find out what exactly to give me. The person who usually handles that was not there. I don't know why she's not trained. She also told me in a very insulting way, I was warned about you. Because I did see Roberta Boomer at the last Taxi Commission meeting and told her I had a problem with her because every time I asked for the board packet, she huffs and puffs. It makes it very difficult for me to get it. She handed it to me because by law she has to, but there shouldn't. We're just talking about documents that should be at the board meeting like you have here, but they don't want to do that. They feel they don't have to do it. Maybe the law says they don't have to. Okay, the next. Okay, so therefore, finally, I got upset because they were making me a little scapegoat here for their issue of not making the public this information readily available to the public. Right there, it should be right in front of you if they're not going to have it. The next issue is that the website. Regarding the website, it is not user friendly. You look at the front page. I hope you had a chance to look at the MTA website. I hope you took a chance to actually see what their website. It's not right there. You have to go to a lot of different links. All right, they take care of 3 different agencies now: Muni, DPT, and Taxi. So therefore, they should have links of different areas what they deal with. Now, in terms of the board meeting, there's at the top. There's nothing that says board meeting information. There's board. There says board, and it says about us, and then it says board. You go to board. And it actually gives a biography of all the members of the board. It doesn't give you agendas and minutes. You have to figure out the links. It takes time. Now I make under $25,000 a year. I don't have a printer. I have to go to the library to do a lot of these links. Do a lot of this. She claims you can just bookmark everything. Well, libraries don't allow you to bookmark on their computers. Okay, so that's the problem. So people looking at the public can't bookmark this. They have to spend time looking for it. In San Francisco, you only get 1 hour total time, 2 half-hour time periods of reserved computer. By the time you figure it all out, your time's up. And also at the different meetings, they have the agenda packet items set different ways. On the particular meeting on April 7th, I was referring to, there are 722 pages. You had to cipher through all 722 pages to figure out where your agenda item is. Later meetings, were actually separate separate areas where they identify each agenda item. All right, but they need to separate each agenda item and each link like you do. You click on your number and you get to your particular documents. That's why I mentioned it. They don't do that. They combine it. You have to cipher through everything, or have a good computer that has a good software that you can actually bookmark everything bookmarked. So I'm telling you that the issue is whether it's user friendly. If you're a geek, it's user friendly and you can figure it out each time, but it's
Thank
not.
you.
Thank you.
Are there other parties to the complaint wishing to present facts or evidence? Seeing none, is there a representative from the MTA?
Good afternoon. Thank you for your time. My name is Roberta Boomer. I'm the secretary to the MTA Board of Directors. A couple of things. We've been committed since 1999 to public access to our documents, and we have posted every calendar item, every staff report associated with the board agenda on the website. Not only on the website, but for people with sight, but also in an accessible version. This has been very important to us for many, many years. We get 160,000 hits a month on our website. Most of the time, people are looking for bus routes, fares, how to get there, citations, parking tickets, permits, passes. About 20 people a month look at a board agenda. That's less than 1%. So it's a very small amount, and sometimes it's me, because I always want to make sure that the materials are available online. So I did bring for you the website. I don't know if you had an opportunity to go on the website. I do have on an overhead.
Wow,
So-
look at that.
Oh, there we go.
If you go on the website, there's actually 4 ways from the home page to get to us. I'm only going to show you the 2 of them. Actually, I'll show you one. You could go to About Us, and that will get you there. The easiest way is A to Z links. If you click on A to Z links, and you can see here, the most popular, people want to know about buying passes, jobs, lost and found, things like that. So if you click on A to Z, you can then click on Agendas, SFMTA Board, or Board Meetings and Agendas. That'll take you right to this page. So here's our agenda. You click on that. It takes you right into the agenda. This is the front page. And you scroll down before the agenda starts. Here are our calendar items. Again, accessible PDF, attachments to calendar item, draft plans, etc.
Can you move it over just a little bit? I couldn't quite see this.
Oh, I apologize.
And again, thank you.
Now, if you click on calendar items, it opens up to the first calendar item, and then you could click on any calendar item that you'd like to see. So the materials are accessible. They are available. Now, that's only one way that you can get to the board website for the 20 people who actually do go. I want to go, though, to another item, if I may, and this is the incident between Mr. Toronto and Roberta Anawai Morales. We normally have 2 receptionists at the front desk. Not only are they there to respond to people who come and want to know about color curb cuts, citations, taxis, traffic, business meetings, job applications, a huge amount of information. They also answer our main SFMTA number. So if a member of the public wants information, now we have them call 311, but a lot of them call 701-4505. On this particular day, Ms. Morales was by herself. The other receptionist was away. She wasn't a substitute. The phones were ringing. There were other people there. Mr. Toronto did arrive and ask for the budget report. She wasn't clear what it was that he was asking. She wasn't familiar with the board that this was something that was discussed the day before in the board packet. So she asked him if she could have a moment. She said she wanted to make sure she was providing him with the right documents. The question really here is, what's a reasonable time frame? Now, in your city attorney's response, it says, the public has, or the staff has 10 days in which to provide something. That's clearly way too long for that. In this instance, it was minutes. She got on the phone. She attempted to find, first of all, her supervisor, who was stepped away from her desk. She immediately called Mr. Ford's assistant. They both came out. Mr. Toronto was clearly agitated. And you know what? He was upset, but we still have a responsibility to provide the documents. He got the document he was looking for in less than 5 minutes. So that's about all I have to say. Thank you for your time.
Thank you. Are there other parties of the city who wish to respond and give testimony?
Hi, good afternoon. I'm Jamie Publitz. I'm Nathaniel Ford's scheduling coordinator. I provided a document just stating the incident, and basically, Roberta called me because she couldn't find Caroline, and I assisted her. While I was on the phone with her, I can hear Barry, who I'm familiar with. I was the board secretary of the Taxi Commission previously before I joined MTA, so I heard Barry screaming at her. And regardless, Roberta kept calm, and she said, just be a moment. I just need to find Caroline and make sure I'm giving you the right information. It wasn't that she wasn't going to give it to him. She just had to make sure that this was exactly what he was requesting. And Mr. Toronto wasn't specific in that. He just said he wanted the budget report. And she's not familiar with our board meetings, so she wouldn't have known. So we found Caroline. We went immediately out there. I talked to Mr. Toronto. I told him to calm down. He knew who I was and said, relax, we're going to give you the document. We immediately gave it to him. So end of story. So he came in, he got what he needed, and it took less than 5 minutes. So that's all I have to say.
Thank you. The matter to the task force for discussion and questions.
Please. I just wanted to find out from the MTA how, maybe you can't give this information, but how thick is the average packet for a meeting?
It's quite thick.
It's quite,
double-sided.
Would it be possible to just do what we do, and I'm not saying it's required, but I think it's best practices, is to bring a hard copy of the packet to the meeting so that members of the public who maybe did not have the opportunity to go online before the meeting could see, have a copy of not only the agenda, but the materials that are being discussed by the agency.
I can appreciate the suggestion. I've been in this position for 16 years. In the past 16 years, I've never brought a board packet, and every once in a while, once every 7-8 months, I would get a request. That was before we posted all the documents online. After we posted the documents online for the past 9 years, I get no requests, except occasionally from Mr. Toronto. So,
are there members of the public who show up to comment on items on the agenda?
Absolutely. And they always seem to have the materials, the printout. You know, we bring backup copies, for example, of PowerPoint. So this is a situation that's relative to Mr. Toronto.
All right, well, just beyond Mr. Toronto, on the off chance that there is a member of the public who shows up who hasn't had the opportunity to go online and get the information, which I appreciate that you have listed.
Well, it is a difficult situation for me. I take public transit home at night. There's a lot of material that I have to carry home. It's heavy. And so, it's a choice that I've made because we have made the materials available extensively on the website. I don't bring those to the meeting, and I appreciate your suggestion.
Any other comments?
Question for, what if someone doesn't have a computer?
The materials are available at 1 South NS during regular business hours.
So they can come and get them?
Absolutely.
Good.
And we have a lot of people. Frankly, we have more people who go there who ask to see the board packet. The board packet is provided upon request to people there. Copies are made. We don't charge the public for copies. And so it's readily accessible.
Please.
I have a question for the complainant, Mr. Toronto. You give us a blanket statement that the website is hard to negotiate, you can't find anything. I think it would be helpful, maybe instructive, to give us an example of something you looked for on the website and for some reason could not find.
I don't think I couldn't. They make it very difficult for you to find. There's a showing.
You said that already. Now tell us about something you tried to find and could not.
I found things, but it took a very long time. My time was up at the library computer by the time I found it. All right, I had to, particularly when I was looking for a particular staff report on a taxi issue back in April, and it took me a very long time to scroll through to find this particular information.
Okay.
Because it wasn't actually separated. It was part of the 722 pages that were combined in all these different documents.
What steps did you take to find? Did you do an A to Z search? Did you type something in on the search line? What exactly did you do? What links did you
after
follow?
finally going through a lot of pages, I finally decided to look on the software program to see if it had a search option. I finally figured that one out. But the public shouldn't have to be required to have to go through all that to find items that go before a public body. That's my concern. As a journalism graduate, as a freelance journalist, as someone has written a lot of articles and wrote for newspapers and covered a lot of public meetings, the public should not have to go through all that to find what they need.
Well, wait a minute. There's a search line on the homepage of the website.
That's new. I'm telling you, on iTorah, that is new. That's new. Okay, but not every computer has that view of the page of a screen, has that type of view that you can see that. But that is new. Mm-hmm. They change their website every few months, and that is the God's honest truth. I know I don't bring religion to this, but that's the truth. They change their website every few months.
Okay, thank you.
Thank you. At this part of our process, the respondent and the complainant both have 3 minutes for clarification or rebuttal. We start with the city, if you have any additional things to add.
Thank you again for your time today. Really, the issue I think before you is what is a reasonable time frame for the materials. Mr. Toronto had the materials he was looking for within minutes of his arrival. We have had the search function on our website for forever. It has always been there. We try to serve everybody the best of our ability, regardless of their nature when they come in. And that's what we tried to do here. And so, thank you for your time. I will just say one more thing. I actually, in preparing for today, I went online yesterday to find out how many clicks it takes other bodies to get to board meetings. From the SF.gov website, you can get to the Board of Supervisors documents in the same number of clicks as it takes to get to the MTA. Everywhere else, it takes 5, 6, 7 clicks to get to the board document. So we have made it as accessible as possible for the few people who do actually want that kind of information. And we do get feedback from the public about our website. They say that the homepage is too cluttered. They want less, but our commitment to make as much available of this vast organization possible available on the website. It's not an easy task for the one guy who has to manage 30,000 separate web pages. Thank you for your time.
Thank you. Mr. Toronto, you have additional 3 minutes if you'd like to take it.
Again, Chairman Chu and fellow task force members, I appreciate the time in hearing this. The point I'm trying to make is that more people probably would be interested in what happens at an organization that spends $750 million a year on public services. And I think that with what's being proposed, as you know, the Board of Supervisors are not happy with what's being proposed. Luckily, we have somebody like that can veto this. My reason I bring this up is because the public is not enough members of the public are participating. And I think if they make it a lot easier for the public to get to this information, and if because they don't, people not necessarily they're not interested. But the thing is that the front page they should say meeting information. Other organizations do it. Entertainment Commission says meeting information. Board of Appeals, meeting information. These are all organizations I'm interested in. Police Commission, meeting information. Police, when you go to commission, it's like 3 clicks. That's it. But the thing is that you shouldn't have to go so far to find an organization where they spend $750 million a year. And now the thing is, before when they were across the street, they had it on the table. It was great. I sat there at the chair. I looked at the packet. I asked the receptionist, can I make copies? They were nice enough to let me go and actually use the copy machine myself. It was wonderful. But right now, you have to go through a series of steps, including signing at the front desk and going upstairs to ask for this information. It is not as easy. Yes, you can have access to it, but you have to go through too many hurdles for something as important as the MTA board. Thank you.
Thank you. The matter to the task force for motion and deliberation.
Sure.
Yeah.
I'm satisfied that the MTA A, made a good faith effort to comply expeditiously with the request for documents. I'm also satisfied that the MTA makes a good faith effort to keep its website current and user friendly. At the same time, one thing that the complainant mentioned is that he was using a computer in the public library and had to give that up after half an hour. And I think that's problematic. In a perfect world, there would be a lot more computers there at the libraries, and time would be, the time allotted to each user would be a lot more than half an hour. But we have to deal with what is. Anyway, in light of what's been presented before us today, I move to find no violation.
I second that.
I do think the MTA website is very confusing. I've actually been very confused myself often on the MTA website. But I think that it's also, as Mr. Taranto said, it is a $750 million organization that is very complex, and it's not the Entertainment Commission, which is about having meetings. And so I can understand, and I can understand their issues with organizing their information. I don't think that there was difficulty getting these documents. I would really love for the MTA to have access to paper documents at the meeting. I know it's very difficult, and there's a lot of logistical issues. But since there are a lot of people looking for these documents that are coming to your office for them, it might be more convenient for them to just get them at the meeting. But that's not something that's covered in the Sunshine Ordinance. So I agree with Member Nee's proposal. Are there any other issues? Is there any public comment on this item?
First, I'd like to give this, I forgot to hand this for the minutes to be included in the minutes of my presentation to Chris. Listen, I don't think paper's obsolete yet. I really don't think that it would be too much trouble to provide a packet at the hearing for the general public to, say, for instance, to walk in or just find out about the meeting. You never know at the last minute. But I still don't believe it's obsolete. I still believe we have to sign papers with ink. And I know for a fact that everybody in the world does not have a computer. I know maybe everybody in City Hall has a computer. Maybe everybody in the upper crust level has a computer, and maybe half the people in the lower crust or the lower crust has a computer, but I don't believe the bottom layer or the lower upper crust has a computer either. So I really believe that it's strongly that a brief or a packet to be left at the hearing is not too much trouble. It can be recycled. It can also be used as an extra copy for the records. It's sitting in a binder. Nobody takes it home. So I don't believe it's too much trouble. And if you give, by the way, the public can come down to the office and get a whole copy for free. Well, I think that may be a little bit more expensive than providing a copy available for anybody to read without a charge or without giving it away for free. I find that I actually am very delighted to hear that 10 days I can request something and get something from the MTA when I can never get anything from the old taxi commission, which I've still, requested some information I still haven't gotten. So I'm grateful for the improvement, and also if you can provide a free copy of the packet, that seems to be an improvement too. I only hope they operate in good faith. Thank you.
Thank you. Is there any additional public comment? If there's no more comments from the members, we'll take the vote. Did you have something to say?
I just want to say I appreciate what Roberta said, that, and also what this gentleman for the taxing. Everybody, especially in the neighborhood, the southeast sector, they have not been educated to computers, really. And it's a lot of information that they ask on the street, and some of them don't even have bus passes to know where to go to. So if I'm in agreement with him, if it could just be a package with them, a lot of people just don't even know how to click. And really, I really haven't really learned how to do email that good. So, if we could take in consideration, but I've looked at yours and it's good. So if we would consider the lower layman person that really does not computer literate, because there's so many people out there, and with the budget cuts, they've been trying to teach them, but they can't get, it's been cut. So it's so many people out there that want to know so many things, and they don't know where to go, and they really don't know how to go, on this computer. So I'm old school. I still believe in a hard copy. I'm not too much technology. I'd like to back it up with, but I appreciate what you have done. I think you've done a good job.
Thank you. You take the roll, call the vote. Call the roll.
On the motion, Member Craven? Aye. Member Craven, aye. Member Nee?
Aye.
Member Nee, aye. Member Cawthon? Member Cawthon excused. Member Washburn?
Aye.
Member Washburn, aye. Member Knebber?
Aye.
Member Knebber, aye. Member Johnson?
Aye.
Member Johnson, aye. Member Chan? Member Chan excused. Member Goldman?
Aye.
Member Goldman, aye. Member Williams?
Aye.
Member Williams, aye. Member Chu?
Aye.
Member Chu, aye. Madam Chair, there are 8 ayes.
Thank you. So we'll move on to the next item. Can you call number 8 and 10 together, please?
Item number 8 is determination of jurisdiction on complaints filed by Save Our Richmond Environment against the San Francisco PUC for not responding in a timely manner. Item number 10 is determination of jurisdiction on complaints filed by Save Our Richmond Environment against the San Francisco PUC for not providing requested information.
And members, before we go into this item, I request to be excused from items 8 through 12 because my partner works for the PUC and I have been recused from these matters previously. Without objection?
Without objection.
So, members, I move that we find jurisdiction on items 8 and 10.
Second that.
Any member comment? Seeing none, is there any public comment? Can you call the roll, please, on jurisdiction on 8 and...
On jurisdiction on item number 8 and 10, Member Craven.
She's
recused. She's recused.
Recused. Member Nee.
Aye.
Member Nee, aye. Member Cawthon. Member Cawthon excused. Member Washburn.
Aye.
Member Washburn, aye. Member Knebber.
Aye.
Member Knebber, aye. Member Johnson.
Aye.
Member Johnson, aye. Member Chan. Member Chan excused. Member Goldman.
Aye.
Member Goldman, aye. Member Williams.
Aye.
Member Williams, aye. Member Chu.
Aye.
Member Chu, aye. There are 7 ayes, Madam Chair.
Thank you. Is Mr. Fat here?
I see him.
Did we expect him today?
He's not shown up for the complaint.
He has
committee.
never shown up for any hearing or meeting.
Okay. Is there anyone wishing to give facts and evidence in support of Mr. Fat? Seeing none, is a representative from the PUC here? Good evening.
Good evening,
You have
Chair
5
2
minutes.
and members. Nice to see you all again, sort of. As was reflected last time, we met on very much the same matter. In fact, I have to confess, I don't know that it's even a different request for information. We were found in violation last time, having been late in providing documentation. However, we did provide evidence that we did, in fact, provide the documents requested. We're before you again on much the same matter. However, I think item 10 is a bit different in that it's asserting that we didn't provide documents. What we did provide were documents and then questions requesting clarification about the request, because our reading of the agenda items from our commission is not consistent with the complainant's reading of those same agenda items. Our reading of them does not include specific projects, 6 locations, 12 projects, etc., whereas the complainant's reading of the agenda item goes into some detail. I I guess I want to assert that I think that there may be two separate items mixed here, but I'm unclear as to which two they might be. And so we requested clarification. None was provided to us. We did get back from the complainant that how dare we ask him what we meant by project, and him asking for the definition or the specifics of 12 projects. We could not find reference to 12 or 6 or any projects in the agenda item he was referring to, which I'm sure led to our question. So in terms of jurisdiction over timeliness, having to sort out Mr. Wingfat's request for information, and as I said before, and as we said at the Education Committee, things fall through some cataclysmic size gaps at the PUC. We do the best we can. We have at this time supplied all of the documents requested by Save Our Richmond Environment on all 7 out of the 100 requests for documentation we've received from various parties this year. I have the files that indicate all of that, and I'm happy to answer any of your questions. And I appreciate your time and patience.
Thank you. Are there other parties of the city who wish to respond? The matters of the task force for discussion and questions?
I just don't, for me, I don't know what the complainant has to complain about now. I don't know if they got what they wanted, if they did get what they wanted, so I just don't see how we can find I'm having a mental lapse right now. A violation, thank you. How we can find a violation, because I just don't see where they're not in compliance.
Okay. Ms. Gauthier, have you ever asked for an extension on the time? That might be helpful.
I think there was a couple of correspondence that were bounced back when we were attempting to make contact. It was to a particular email address that was changed, but I do have a couple of bounced back emails. We were just trying to reach the requestor because we knew we'd have to go off-site and out of our agency, which takes more time.
Right.
But given the bounce backs, we just kind of pressed on and tried to find the information.
Okay. Well, it's just an idea that you can always ask for an extension if you need it.
Can I ask a question?
Of
course.
course.
On this sheet we have this supplemental sheet of the requests of you, and I was looking through it from the Save Our Richmond Environment. Item number 20 on here, it looks like it took you 2 months to respond, but as it went on, it all kind of came into compliance. So am I correct in thinking that at the beginning you're still saying that you had some problems with timeliness, but you kind of worked through that?
Well, I would love for that to be a reflection of that, but in fact, this particular issue is that this was just not addressed.
Okay.
And there were two... and so it sat on someone's desk unopened for a while. And concurrently with that, there was an issue between Save Our Richmond Environment and our general manager's office, asserting that we made no attempt to contact him about something. And so there were two parallel paths, and I think folks at the PUC were sort of confused as to who was asking who for what.
Okay. Thank you.
So from your testimony, we should find you in violation?
Well, he didn't complain about that
You
one.
can make it simple for us. Be able to move
You
forward.
could find me in violation on the timeliness, but I'm really sincerely unclear on the nature of the number 10 complaint. So it's up to you to determine whether or not that's even a valid complaint. Given that you've accepted jurisdiction over it, you could find no complaint or no violation.
Well, see, that's the one that I have a problem with. I can see the timeliness, but number 10, I don't have any information here from the complainant saying that they didn't get what they wanted or not. So,
right. Yeah, I read that we were asked for information and replied with, we'd like clarification.
Right.
And then
No response.
we got clarification and we answered his question. So he didn't like the answer.
Right. Okay.
Anyway.
Unless there's any other
Are
questions.
there any other?
So the respondent and complainant have another 3 minutes. If there's anything additional you'd like to add.
Well, I do appreciate your efforts at supporting good government and good policy, and as I make those efforts myself, at some point I would love to sit in on with a committee of you or others, although not a quorum, because that probably wouldn't be a good idea, just to look at how the Sunshine Ordinance is enforced and what happens with complaints, because it just brings to mind sometimes vexatious litigants and things like that become very much a drain on all of our good resources and keep us from doing the really good work that we want to do. So I appreciate that consideration.
Great.
Thanks.
We have a committee that's working on some amendments, and so they might love your feedback on that. The matters of the task force for a motion. It sounds like we have two motions. It sounds like we're leaning towards two motions. One in timeliness on the first item, or at least I'm thinking about it. 09021 with timeliness, which would be 6721B. Am I getting that right, Ernie? And then no violation on the 09023.
Are you making that motion?
Yeah, I'm making that motion.
I'll second your motions.
Okay.
Just with an added, since she's generally asking for education and outreach for a referral to put it on the agenda for maybe us on the Education Outreach and Training Committee to get back with her and set something up with what we can do, what we cannot do.
Right. Well, that's a good idea. Or we can go to compliant amendments to talk about. Does the amendments address vexatious? Repeat requesters and all those issues?
No.
I forget.
No.
Okay.
When you say repeat requesters, are you talking about the so-called vexatious?
Yes.
But I don't believe it does, and I think I don't believe the amendments do address that question, and I think that in past discussions of that matter, we've been very reluctant to do that for First Amendment reasons.
Yeah. I mean, I can see that, but at the same time, I think we also need a place where the city can discuss that with us. Instead of saying it's not happening or it's okay, we can at least talk through.
Well, again, we're treading into some possibly dangerous ground there.
Discussing it is treading into dangerous ground?
No, I mean, the issue, discussing it is one thing, but an amendment itself, could be broaching some First Amendment issues there.
Right. No, I get it. I just feel like for different departments, it's very frustrating. And here's a new department coming in front of us, and she's frustrated. And so we can at least have the conversation out loud that yes, we know this is going on. Here's the reasons why we're reluctant to do anything about it. Here's some process things that might help.
I have no problem with bringing that back on the next Compliance and Amendments Committee agenda if that's if that's deemed advisable, certainly. And Mr. Rustum, could you please note that?
I can forward this order determination to the Compliance and Amendments.
That's fine.
As a discussion item.
That's fine.
Okay.
But I also agree with Doyle that there are parts of this that fall naturally into the EOT purview in terms of doing something proactively to help departments to meet requests expeditiously without burning up too many resources. But I agree that it would be a very slippery slope indeed to put this into an amendment to the law.
Well, why don't we start a compliance amendments, and you guys feel like that the EOT can add something? Can you send it over to the EOT committee?
Certainly.
Thank you. Is there any public comment on this item? Seeing none, is there? Can we call the vote, please?
On item number 8 and 9, to find violation of timeliness.
9 and 11.
9.
9 and 11.
9 and 11.
Shouldn't this be
They gotta
split?
go separate, yeah.
We've split it again.
Yeah.
Well, we already voted on 8 anyway. It's not on 8 and 9. It's just on
Over 9. 09021.
On item file number 09021, Member Craven recused. Member Nee.
Aye.
Member Nee, aye. Member Cawthon excused. Member Washburn.
Aye.
Member Washburn, aye. Member Knebber.
Aye.
Member Knebber, aye. Member Johnson.
Aye.
Member Johnson, aye. Member Chan excused. Member Goldman.
Aye.
Member Goldman, aye. Member Williams. Member Williams, aye. Member Chu.
Aye.
Madam Chair, we have 7 ayes. On file number 09020, Member Craven.
2-0? It's 2-3, isn't it?
Accused.
2-3, sorry. On 2-3, Member Craven recused.
This is as to no violation?
As to no violation.
Thank you.
Member Nee.
Aye.
Member Nee, aye. Member Cawthon excused. Member Washburn.
Aye.
Member Washburn, aye. Member Knebber.
Aye.
Member Knebber, aye. Member Johnson.
Aye.
Member Johnson, aye. Member Chan excused. Member Goldman.
Aye.
Member Goldman, aye. Member Williams, aye. Member Chu.
Aye.
Member Chu, aye. Madam Chair, we have 7 ayes.
Thank you. I believe we're up to number 12 on the agenda.
Item number 12 is the Compliance and Amendments Committee has referred to the task force for further consideration its recommendation that the 09006 Joshua Arce and Eric Brooks versus the San Francisco PUC matter be forwarded to the Ethics Commission for failure to comply with the task force's March 24, 2009 order of determination.
Member Nee.
At the Compliance and Amendments Committee meeting of May 12th, both sides appeared, and there was consensus among the two of us who were weighing in on this issue. Again, Member Craven Green was recused. Member Johnson and I agreed that there is cause here to refer the matter to the Ethics Commission. The order has not the order of determination has not met compliance, and we feel that's cause.
So the order of determination asked the PUC to search for additional email records? And that's what's not been done?
Well, more than that, there's also the question of the practice of the PUC to destroy emails after 6 months. And as a matter of fact, on the particular information that the complainants were seeking, that 6-month timeline, I believe, did pass. The complainant or the respondent will correct me if that's incorrect. And this goes to the whole question of proper record keeping on behalf on the part of the PUC. I believe I asked the PUC to give us some kind of an indication as to how they were progressing on making on making their system able to store records, store their emails longer. And if memory serves me correctly, and Member Johnson will correct me if I'm wrong, I don't detect any desire or effort on the part of the PUC to do that. And this goes, I think, counter to the record-keeping requirements set forth in the ordinance. So, given those facts, I think that it is appropriate to send this matter to the Ethics Commission with the finding on our part of willful failure.
So, Mr. Lorente, does the Sunshine Ordinance require that emails have to be kept longer than 6 months?
I think that what we had here was the Sunshine Ordinance says that the department would set up their records retention policy. I think what was here was that there was a request for information, and it was available, but then it was deleted. And then there was a period of time in which that information could have been retrieved, but that time passed, and there was no longer a time, like after 6 months, there's no way you could retrieve it. It was just written over, so it was lost. So there was a period of time where there was an opportunity to retrieve it, although it's not readily available. It would be something where there would be some effort to retrieve it. It's basically trying to go into backup systems and try to get raw data and try to pull out the information that you would need. So the fact of the matter is like you said, there was a request for the information. The information was available at one point. Then it was deleted, but it was still available in a backup form. But that time has also passed, and therefore it's not available.
Okay, so what you said is in my view, very different than what Member Nee said. Member Nee said that they're not. Well, I heard it differently. That their processes need to change, and I don't believe the Sunshine Ordinance requires their processes to change. I think we'd like them to change, but I'm not ready to say to the entire city, you cannot delete emails in 6 months, because that's what we're saying. If we go to the Ethics Commission with this, we're saying no one can delete emails every 6 months, and I don't feel like we know enough to say that to every part of the department. I do think that line that says the task force requests the PUC for additional email records, and to go into what Mr. Valente said, hey, get on it right now, go in and do that. You said you can do it. You need to do it. And if they didn't do that I find more of a violation than, or I find closer to willful. Yes, closer to willful than.
It's just not to comply.
Right.
That's why that's the base of what I think is the recommendation. Is just the willful failure to comply. But we're not going to comply, and we're just going to wait for that information to disappear.
Right. So they came to your meeting and said, no, we're not going to. Well, I guess the timing was bad for us too. Right. Yeah. So my other issue with this is what we expect from the Ethics Commission.
Also, this issue keeps coming up, and even though it's not under the sunshine in the Good Government Guide, emails of importance are suggested that you keep them as long as you would any other important document. So if you keep documents for a year, if you only keep them for 6 months, then that's what you should do with your emails, according to the Good Government Guide.
Right. No, I agree with that, but we're working on the electronic document, like our own recommendations for. I mean, until we can get our own house in order and then move on with that. I mean, I think that's a sort of a process, and also working with DTIS to figure out how this is even done. It's one thing to say to go back into your records and do it, but the thing that's bothered me in this case is the PUC came in front of us and said they could do it. That they have done. I believe that's this case, right? I mean, that's why we put it in there, is that they've done it in the past. That was the thing that was like, okay, you've done it, go and do it. So, what they did. Sorry.
Well, my question is, what is our hopeful outcome from the Ethics Commission by putting this in front of them? I mean, there is two parts. I don't think that we have anything that we can do with the 6 month policy. I agree with Chairman Chu. I just think that is a policy issue that we can make recommendations about it, but I don't think that we are capable of making sound judgments about city policy in that regard. But secondly, I'm not opposed to this at all. I'm not seeing the end result in my head. What are we looking for? What are we trying to get out of this by sending it to the Ethics Commission?
Well, I think that we have to prove willful. And is willful a singular person, or can a whole department have? I mean, the problem is then we got
the department head is ultimately responsible.
So we need to prove the department head.
So I mean, if the staff is doing this and it's under the policy of the department head, then the department and the department head is responsible and is liable, basically. But again, I mean, I think I wasn't present at the full task force when it was heard, and was it Mr. Windecker who said that they were able to retrieve this information? Because at the compliance and amendments, it seemed a little different from what I heard, that it was going to take more effort, and then there's a 6-month retention policy, and in 6 months the information is written over because of capacity problems, and that's the way that system is operating right now. So,
Well, I think when it came before compliance and amendments, these things had already been written over. Is that the right timeline? That we had missed that window. I don't. I'm sorry.
I think it was coming up. Yes, I think it was.
Perhaps the complainants are here. Perhaps
Yeah,
they could
we
help
can-
us on this.
if they have
could
more
one of the
information.
complainants approach the microphone,
On the
please?
timing, if you have any.
Yes, Joshua Arce, one of the two complainants here. Just to point you, in case the transcript's floating around, I know you've got documents everywhere. It's at page 8 of 22 of the transcript where Mr. Winokur had stated that, yes, records had been restored from, deleted emails had been restored from backup tapes. At the time he was before the full task force, he said that we go back a year. And then before compliance, he apologized for making that mistake and said that those emails go back 6 months. What I think, though, was the bigger issue was that there's an email, to the extent you still have your briefing packet here, it's in page 80 or 81. It was a June 3rd, 2008 email from the SFPUC Public Records Custodian that says, I'm not aware of any emails that would be responsive to your requests that have been deleted. So they were there. They were had been deleted for just a couple months, and if they had been restored at that time, we wouldn't be dealing with this issue about 6 months going by, and we lose everything in December. And like I say, I've got page 80 or 81 if you have that, Chris. But I think that was something that to say that, well, obviously an inquiry was made from the custodian along the lines of, hey, staff, is there any emails that have been deleted? Staff apparently said no, comes back and writes to complainants, we're not aware of any emails that have been deleted. But gosh, it could have been restored. That was like a month or two after they'd been deleted.
Yeah.
And so I think that was part of the idea for willful.
Yeah. Well.
Yeah.
It has. That was failure. Willful failure is we asked them specifically to do it and they didn't do it.
Yeah, we're
the-
talking about since that finding, not about that date. It's since that we asked them to bring it back, and now if they're not available because they just let that lapse, that's where the willful comes in. That's what we're trying to determine, that timeline.
Okay, so that the period before the determination doesn't count, just as far as I think one of the task force members has said, well, the emails were sitting there for 6 months. They knew that complaining parties were trying to get them. They say there's been no deleted emails. Couldn't they have gone at that time?
Right,
Instead
no.
Of,
Yeah, and that's
that does or doesn't figure into it?
Well, no. What we're thinking, no. What we're trying to figure out is how to make the argument to ethics. And the argument would be that would be the original violation, but what we're arguing is the willful violation is that even after all that happened, they still had an opportunity to go back and do this. And if I understand the timeline right, particularly because we talked at ethics, we made the determination it was less than 6 months at the full task force. Even at ethics, when we were all talking at ethics, at joint ethics meeting with Sunshine, we were still in the window of 6 months. And then by the time you came to compliance and amendments, I believe it was outside that 6 month window. So theoretically, they had already been destroyed. That's my understanding of the timeline.
Yeah, that's I think where the willful comes in, right? Is that they still had a window to be able to go back and try to do this, whether they could or not, to try to do this and get it done. That is by completely ignoring that after the determination has been made. That's where the willful. I mean, in my mind, that's where the willful comes in.
Right.
Thank you.
Wait, so is willful malicious?
I don't think that you could equate them together like that. Malicious has the Latin root of malum, which is evil, and that's not what this is. Basically, an intention to do the act that they are doing, basically, and it's willful failure equates to official misconduct. So they're willful. I refuse to comply with your order. They may be maybe a nice person, they may not be evil, but they are not complying. That intention makes it official misconduct.
Right.
But if they're saying, I'm doing it because I want to hurt you, I'm doing this because I'm gaining a financial advantage, then that's something different. But like I said, I don't think you have to find malicious here. You just have to find an intention to do the act you're doing in violation of an order to do it, basically.
So it sounds like he came to compliance amendments and didn't say I refuse to do it. He just said I didn't do it.
He said they couldn't do it now because it's factually impossible to do it now.
Okay.
He said, I thought it was a year, and it was 6 months, so now I can't do it.
Yeah. So sorry, I made a mistake. I thought it was a year. It was 6 months, which means that I don't know whether there was any negligence involved, whether there was a lapse. They could have acted, and they just kind of sat back thinking, "Oh, I have a year when I don't have a year." I don't know.
Mr. Arce? Did he really say a year at that meeting, or did he say 6 months?
On March...
Thank you for having our transcript.
Yeah, sure. On March 24th, Mr. Winokur said that in theory we could go... he says, it's my understanding tapes are kept for a year before they're overwritten. Chair Chu says they're taken daily and kept for a year. Mr. Winokur, I believe that is correct. And then you said, has it ever been done? And he says, I believe in some cases they have restored emails from the backup tapes, deleted emails from backup tapes.
Right. At the Joint Ethics Commission Sunshine thing, you knew about the 6 months. How did you find out about the 6 months?
No, I didn't know about the 6 months. I said that there's a clock ticking, and if the PUC is in a position to rely on the argument that, hey, we didn't know we needed to do all the restoration of emails, that it would frustrate the process. So I was asking, please notify the PUC that you got to delete these or restore these deleted records.
Right. Okay. I don't know.
This is difficult.
I mean, the problem is he thought he had a year, and
I mean, this is a he said, she said. I mean, he said, she said thing, because did he know 6 months, a year? Did they sit on it?
Right.
Did they not do it because they thought they had a year? Would they not have done it even if they knew they had a year?
Right.
I mean, this is all the stuff we got to swim through.
Well, so my concern is this would be the first time we take it to the Ethics Commission when they've agreed to start participating in the process a whole lot more than they have. And is this the one we want to send there? I mean, don't get me wrong, I'd love to send it, but I just don't know if this is the first one, because, we, at our joint meeting, we said, we're going to bring all, you're going to give you transcripts, we're going to tell you exactly what happened, we're going to give you all the evidence, we're going to, and so I was hoping the first one we sent was a slam dunk.
Is it a simple matter that they acted in bad faith? Or even if they acted in ignorance, is it the responsibility of a public body to know their own processes?
I don't know. I mean, the problem is that we had a discussion about willful failure, and
See, that would put a strict liability standard that you should have known. But what if you made a mistake and you did it? You thought it was this and it wasn't. Does that make it willful? It says, "Hey, we're going to comply because we have a year." Then, oh my God, we don't have a year.
That's the thing. That's a problem that I have, because this becomes the he said, she said thing. I mean, what we have to get into the head and say, did he not comply? Did he not intend to comply with, even if it was a year,
right.
Or was it really because we lost track of time, didn't know it was only 6 months?
Mr. Arce?
We should read.
Yes, Madam Chair. If I may just also highlight, going through my notes at the last compliance meeting, it was also brought up later in the discussion that there's already been a finding of violation under 67.29-7, and I understood that the committee was referring that finding of violation to the Ethics Commission for enforcement, and my understanding was leaving aside the separate issue of official misconduct under 67.34 to possibly be determined by the Ethics Commission, because I think, as was discussed before Ethics, they have a separate investigation, and a lot of us have been interviewed already about that. So I was left with the impression that 67.29-7 was being forwarded to the Ethics Commission for enforcement, and perhaps the idea was willful failure, official misconduct might be subject to Ethics' own investigation, which has a separate file number.
Right. The problem with that, that we were discussing earlier is deleting your emails every 6 months isn't necessarily bad business, isn't unprofessional.
We're not in the position to be able to determine what their policy should be. I just don't think as a body we're able to do that.
But if I'm correct, there was a separate violation apart from official misconduct or not. There was a finding of violation of 69-29.7, requiring all department heads to maintain and preserve in a professional and business-like manner all departments and correspondence. That there was a finding of violation. That I'm new to the process, so I don't know what the enforcement mechanism is at ethics. But to me, it seems like you did find that violation.
Well, that violation is on before they deleted those emails in the first place. There's two separate issues. We found them in violation for deleting those emails in the first place. A separate issue is if they can get those emails back. That's where the line is. I mean, we found them in violation for deleting the emails that were pertinent to this. And the problem that we're having here is trying to dictate a policy of how long you keep deleted emails on record, and that's why we have a separate issue here.
Then two questions. I'll just step right back. The first question is: do we know for sure that there is a document retention policy that says we're going to keep this for 6 months, or was it an arbitrary 6-month determination? And two, can the proceeding be held in some sort of animated suspension to allow that ethics separate investigation that they have to go forward?
I'm sorry, Chris.
Madam Chair, in my draft meeting minutes for the CAC meeting on Tuesday, May 12th, Mr. Winokur I reflected what he said. He said SFPUC General Manager Ed Harrington, in an email to Mr. Arce last year, had mentioned that the tapes were kept for 6 months before they are overwritten.
Okay.
And as I told Mr. Winokur, please show it to me because I've never got it, and I haven't seen it still. So
Don't say that. that's our argument.
Yeah, I was just wondering if we had told Mr. Winokur to retrieve those emails, shouldn't he have attempted to do that in a timely manner and not just sit on it? I mean, that's a separate violation. If that information is available, then you give it to the person who requested it.
Unfortunately, we wrote as soon as possible.
And that's the problem. It's not on the same. It's not under the same jurisdiction as us requesting under Sunshine or something like that, saying that we have 10 days. We just said, please comply, and we don't have. There is no legal standard for that there.
So it's my understanding from our ethics commission meeting is that ethics is looking for willful failure. They're not looking for anything else. I mean, someone either willfully failed to comply with the Sunshine Ordinance. There's no, they're not going to find a violation of someone not preserving their records in a professional and business-like manner. They're going to find someone in violation of, willful failure, which is slightly different. So we can't, as Mr. Darcy said, we can't just say to them, ethics commission is going to go, PUC, you have to, make your email system better because because they're ethics, right?
Right.
It's a different sort of state, way that they approach it. Yeah.
We had found jurisdiction before. Now this is a separate entry. I believe sometimes the department can go over and beyond. It has been several departments have gone over and beyond. If they knew that this has been going on, and in good faith with the public, they could have gone back and tried to restore it. There is such a thing as good faith. You don't have to. And you keep saying it's non-professional. I don't believe it's non-professional. If you're trying to serve the general public and you're being paid, it is your obligation and your responsibility to do anything in your power to give the person the records that they need. And we keep going back and forth and back and forth. And if these departments want to be in good faith and work with us and work with the general public, and if it's not, I don't like the word maliciously, it's not willfully and they don't have anything to hide, give it to the people. Give it to the people. What's the point? that we keep going back and forth over these little technical things about it. If you don't have anything to hide and if it's nothing to do, what's the hold up? We keep beating a dead horse to death. This is what we do all the time. We beat it to death over and over. And there has to be some good faith between the citizens and the departments of San Francisco for them to trust the Board of Supervisors, the record keepers, and most of all, to trust the Sunshine Task Force.
Do you have a recommendation, Member Williams, on how to proceed?
Can I? I agree. I do think that there has to be good faith, but I understand. But what we're trying to do here is, unfortunately, kick-start ethics into backing up our decisions. And to do that, we have to lay it out. We have to give them basically the path to follow. And I believe, and I think that this is a very difficult case to do that, because I do think that the PUC didn't do what it was supposed to do, but was that willful or not? Unfortunately, I'm not a mind reader, and I think that's what it comes down to. We have to prove, I mean, if we want to give this to ethics and make them act on it, we have to be pretty darn sure that what PUC did was something that they should not have done. Not a mistake, not an oversight, although that is a violation. It is something that they chose to do in defiance of our order. Anything less than that, I think, is a waste of time for us. I mean, don't get me wrong. I do think everything should be on the record, but for the purpose of trying to get ethics to act, I think we need to be able to lay out that roadmap, and I just don't see it here.
What do you guys on the complaint committee think?
Well,
The compliance administrator.
Unfortunate, though. It's very unfortunate. I think that, there has been, from what I've seen and heard, I think that there has been some thumbing of its nose by the PUC toward the complainants. However, this would be, I think, extremely difficult to prove if we were to send this to ethics. I don't think it would fly with ethics. I think ethics would do the same with this complaint that it's done with every other complaint we sent them. So we can do one of two things. I can make the motion that we send it to ethics, and it would probably be voted down, or I make no motion, or nobody makes a motion, and we just go on with our lives from here.
I think that I'm not a mind reader either, but there's a lot of people here that would like to vote a certain way. It's just it's very hard to prove that way. And maybe you don't have to prove everything in the beginning. Maybe you have to do everything in baby steps. So if we were to sit here and vote today and make a motion on how many think here that this is an ethics issue just in that way, then we can let them deal with it. And if it gets voted down, it gets voted down.
So make a motion.
I make a motion to move this, to refer this to the Ethics Commission.
Second.
Any other comments? Mr. Brooks, did you want to say something?
Yeah, I just want to make sure.
Just to come full circle.
I'm the other complainant, Eric Brooks. I just wanted to flesh this out a little bit more. I'm not saying you should necessarily railroad this right over to ethics right now. And by the way, my suggestion on that is come up with a rule that will apply in the future, and maybe send something like this to them right away, that as soon as there is a complaint about non-responsiveness on documents, that agencies need at that point to go into good faith mode, and they need not delete things, and they need to act in good faith to make sure records are retained, even if they don't have the order yet. So that's one suggestion I would have. The argument I would make on the willful violation is that the previous violation and unfortunately it's not in your order of determination, even though it was discussed during the hearing itself on the previous violation, was that staff knew that there were deleted emails. When their documents person went to them and asked them if there were deleted emails, they said no. That was a direct untruth that staff said to their person that was following up on the emails. There aren't any deleted emails that respond to your request. When the staff knew that the department head knew there were such emails. So I think it's a good idea to let ethics dig through this process before you make a determination on this specific item. But I would also say that if we don't eventually come up with a willful violation on this specific item, it's going to allow departments to kick stuff around like a hot potato or a football and play games like that, where they, 6 months previous tell complainants, well, we don't have any responsive documents, and then they can just let the clock tick. It's kind of like the end of a football game where you're ahead and you just grab the ball and don't run down the field. So I'd say let's wait and see what the ethics department does with the entire complaint, and then at that point maybe bring this up when it'll be more clear what exactly happened and what was willful and what was not. And at that point, use this idea that what the department did was the PUC created a situation with those initial untruths that would get to this point where then they would not have to come up with any documents because they'd been permanently deleted. So to me, that is willful. It is a department and department heads creating a general situation around documents requests in which they know if they just slow it down long enough, they will not have to comply. And it should also be remembered that when we brought these complaints initially to the new head of the PUC, Ed Harrington, he was non-responsive to those complaints at that point, and that's why we had to come to Sunshine in the first place. So what they're doing is creating a pattern of non-responsiveness, and that is willful. And they know that it's willful. So you could make the argument, but I think I agree that it's a tough argument. You might want to wait until the full ethics on the previous violations has been fleshed out.
So you have something in front of the ethics? Is that what you're?
Well, your previous determinations. In other words, the fact that emails were deleted.
Nothing at this point. Nothing gets referred to ethics. Nothing moves to ethics unless we decide to do it.
No.
Does that make sense?
I'm talking about
there is an investigation in front of ethics.
Oh.
A separate investigation about
okay.
these
Then that's
ideas.
what we're talking about.
The referrals you made before that led to this particular item.
No, it's separate. They have a separate ethics investigation on something similar to what we talked about.
And it's these emails.
Yeah. Sure. Does the city want to say something?
Is that all you have for me?
Yeah. Thank you. Thank you, Ms. Gauthier.
Yeah, that's fine.
Thank you for this opportunity. I promise to keep it brief. I have not been a party of this particular deliberation. My supervisor, Mr. Winokur, has appeared before you and has spoken to me, and just briefly earlier, actually late last week, to say, will you please go to the Sunshine Ordinance Task Force, although I've worked with Joshua Arce comfortably and believe we're on the same path on this. So frankly, I'm a little startled at the severity of the language here, willful and pattern and malicious and ongoing, and really want to suggest to you that you think carefully before you use those kinds of words. I stand before you having participated in probably a little over 5 years worth of the PUC's compliance with the Sunshine Ordinance, and in good faith with a lot of requesters for a lot of things, and would have to counter that we have a pattern that is quite contrary to willful and malicious, but is cooperative and helpful to the extent that we can be. This, I believe, is an exception to any pattern we've established. And it is an unfortunate situation with Mr. Arce And Mr. Brooks, is it Brooks? I'm sorry. And it is unfortunate, and there are lessons for all of us to learn here. But to suggest that this is somehow indicative of a pattern of willful misconduct or willful betrayal or denial of your order, we at the PUC are working on, and I was just told earlier today, record retentions policy written. We did not delete the emails to get them off of the plate within 6 months. They had been deleted, and our system does not retain those things once deleted for more than 6 months. So that in order for us to change any of that, just knowing the kind of email that comes to me that I delete routinely, let's just say the city's spam filter for me is not that great. So I get offers for medicinal things and Nigerian scams, which I just really don't want to retain.
Thank you, Ms. Brady.
So I would appreciate some consideration, but most importantly, I believe our department's really honest efforts to be good about complying and have a pattern quite contrary to willful misconduct. Thank you.
Thank you. Should we call the question, unless anyone else has anything to say? No, thanks. It's not a hearing. It's a vote.
On the motion to find violation, Member Craven recused.
That's not a violation to refer
to Ethics Commission for.
To refer to ethics, Member Craven recused. Member Nee.
No.
Member Nee, no. Member Cotton excused. Member Washburn.
No.
Member Washburn, no. Member Caneva. No. Member Caneva, no. Member Johnson.
Aye.
Member Johnson, aye. Member Chan excused. Member Goldman.
No.
Member Goldman, no. Member Williams. Member Williams, yes. Member Chu.
No.
Member Chu, no. Madam Chair, we have 2 ayes and 5 noes.
It fails.
It fails. Okay. Thank you. Can you call the next item?
Item 13 is the Compliance and Amendments Committee has referred to the task force for full consideration their recommendation that the 09007 David Larkin versus the Department of Public Works matter be forwarded to the Ethics Commission with a finding of willful failure to comply with the task force's March 24, 2009 order of determination.
Member Nee, do you want to explain the background on this?
Yes, the complainants appeared before the Compliance and Amendments Committee at our May 12th meeting and reported that the order of determination that the task force had issued was still not met. What I might want to do now is, if the complainant is here, to invite him to update us and see where we are currently and go from there.
That's fine. If the complainant can just briefly fill us in on whether or not the order of determination has been complied with as of this date, and then we'll hear from the respondent.
Is Mr. Larkin here? Please approach the microphone, sir. And just update us between 2 weeks ago and now. Have you had any satisfaction?
Task force members, no, I have not.
Okay, Mr. Lee, I believe you're here.
Thank you.
I'm frankly with the Department of Public Works now. We actually don't have any comment on the motion or on the agenda item, but I do just want to repeat what I said in committee, that we were disappointed that we were not part of the discussion that led to your determination, and we still feel that we didn't do anything wrong. And one thing for clarification, I don't think you made the decision on March 24th. I think it was April 28th.
And just to supplement my recollection of the Compliance and Amendments Committee discussion, the question was whether or not they complied with the order of determination. Mr. Lee informed us that he hadn't had an opportunity to talk to his lawyers as to whether they would comply by producing the information that we determined was public information that should have been produced, and that my inclination was to actually continue the compliance and amendments for another month so that Mr. Lee and his attorney could make that decision and figure out whether or not they were going to comply, but that the other members felt that the further delay was unnecessary and that this should be referred back to the full task force, and that Mr. Lee could come and tell us what they were going to do. And maybe if they had produced the documents, this issue would go away. However, I'm kind of confused by Mr. Lee's position. They're not going to comment. That leaves us really with no position, no situation, except to refer it to ethics for finding a willful violation. My hope had been that you would come before us and say, I've talked to my city attorney, we agree the Bakersfield case is the one we should have applied, we'll produce the information. Or you would have said, we've talked to our city attorney and we believe that we were correct and we're not going to produce it. So I'm not really sure what Mr. Lee wants from this body. I'm disappointed in the response. I myself had hoped we'd have this resolved before now. So I'll turn it back over, but that was my background from the hearing. And this is an aside, there was a whole issue of whether or not the department was notified of the initial hearing, and we went into the minutes may reflect this, went into a discussion of that. Mr. Lee felt it was unfair because he had not been notified. He had wanted a continuance. Our administrator had informed Mr. Lee and another person at the department that a continuance by the department is not automatically granted and that they should consider this item would be going forward. The department was on notice that the matter would be heard, and the department did not send anyone, despite having been on notice. And maybe there was some miscommunication at the department's level, but they were fully informed. And so then to have Mr. Lee show up today and say there's no comment.
I would like to comment that unlike the other case, I do see a problem with this because there was no new information, no reason why the department hasn't complied. No comment isn't good enough for me, and I understand there's a lot of extenuating circumstances. There might have been a miscommunication, whatever. They could have brought that information here and explained to us about that. But I moved, unlike the other one, I strongly feel we should move this one to ethics if there is no new information.
A motion?
And I would so move.
Second.
And just to make it clear, would that a motion be for a willful failure to comply with the Sunshine Ordinance and with the order of determination issued on May 5th, 2009?
Thank you.
Any other comments? Do you think we'll have a strong case with ethics? I mean, I think this is the case that could be resolved in 5 minutes with the department turning over the requested documents. So whether or not this is a strong case for the enforcement for the Ethics Commission, I think there's a real possibility that it could be.
Well, I think that point is moot in that it could be over quickly. But I do think that we have a strong leg to stand on for doing this. So I'm not looking at it as a political ploy. I think that we have a strong leg. I don't see any other way we can find with this item with what we have in front of us. So I don't see another way to go.
And I would actually make a motion to amend the order of referral that it should be made under 67, just so it's more specific that when it's being drafted, I think it should be under two bases for the referral. It should be under 6730C for a violation of the Sunshine Ordinance for failure to turn over public records, and also 6734 for willful failure to comply with the order of determination, and willful failure to turn over public records. With respect to, would the maker and the second accept
I agree.
that clarification.
Excuse me, is this in line with your order of determination? It should follow whatever findings you made there.
Yeah.
This is for the referral. Under what provisions we're referring it to the Ethics Commission. There's two separate methods of which it might be referred. And so it's citing those two provisions.
Oh, okay.
If you want my extemporaneous, is that the word? Whether this makes a strong case to the Ethics Commission, I think it makes a clear case. Whether or not they believe that there will still be the issue, I do not doubt it, that the department will say, we relied on our city attorney's advice, that we didn't have to release this.
But
and then there'll be our side that says, basically you applied the wrong legal standard, and under the ordinance, there's no grounds for you withholding this information. You didn't produce it. So there will still be that issue at the Ethics Commission, but I think this is a very clear case in terms of at least its procedural history and what's at issue, as opposed to some other complaints that we've referred or order determinations that we've referred that had 10 different allegations, and we sustained only one, and we referred it to ethics, and it wasn't clear about what the background was. This is a very clear case.
Yeah, and I agree, and it's basically a fundamental issue. It's just this we found, we made an order of determination, and it wasn't complied with because they don't think they should. I think that's the baseline. it doesn't matter if it's a long argument or a short argument. That's the base, and I think what we need to get. Our relationship with the Ethics Commission. That is what we need to get to the heart of, right there. We make an order of determination, and it needs to be complied with. If not, they have to explain to us why, or it is an ethics matter.
Right.
And I guess the factual matter here is whether or not there's been a question directly posed, whether this department obtained advice from their attorney, and are they relying on it, or whether they're just saying, no, we're not going to do it. It's not clear. The suggestion was you're going to go talk with your attorney, and then you'll get back to us. Well, today we says there's no answer. I don't know whether they did or didn't. That's...
And I agree with that, but I think that our two options is to say, well, it's all right that they don't bring us an answer, or we say that they didn't bring us an answer and there's a problem with that. And I think that's the two options that we have. I don't think that we can just say, okay, we're going to wait until next meeting, next compliance meeting, next everything to wait and see if they bring us back an answer. We made a determination. They didn't comply with it for whatever reason. And I think that is the heart of what we need to get at.
Okay, let's call the question, please.
On the motion, Member Craven? Aye. Member Craven, aye. Member Nee?
Aye.
Member Nee, aye. Member Cawthon? Member Cawthon excused. Member Washburn?
Aye.
Member Washburn, aye. Member Knebber?
Aye.
Member Knebber, aye. Member Johnson?
Aye.
Member Johnson, aye. Member Chan? Member Chan excused. Member Goldman?
Aye.
Member Goldman, aye. Member Williams? Aye. Member Williams, aye. Member Chu?
Aye.
Member Chu, aye. Madam Chair, we have 8 ayes.
Thank you. So I'll work on that in the next few weeks, if I can get some help.
2 weeks.
Pardon me? Number 14, I think we're at.
Item number 14 is the review proposed amendments to the Ethics Commission's regulations regarding Sunshine Ordinance Task Force referrals.
Thank you. Member Nee?
Yes, the Ethics Commission is drafting new regulations on how to handle sunshine complaints, and there have been some concerns generated to the task force. You have, I think, the memoranda that Alan Grossman drafted to both the task force and the Ethics Commission. I'm not sure what we can do as a body at this point because it's A, getting late in the ball game, and B, I haven't had a chance to really digest this and draft any substantive suggestions myself that I could bring as a motion before the task force. What I would suggest, though, At this point, I'm not sure any action can be taken today, but what I would like to see is for each of us to go through this, and at the June 8th meeting of the Ethics Commission, each of us should, or as many of us who have the time and the energy and the desire to do so, should be prepared to come before the Ethics Commission with some specific guidelines, some specific proposed guidelines on how ethics should deal with sunshine complaints.
Can you summarize Mr. Grossman's issues? I'm in your boat too. I didn't go through the material in any kind of detail.
What he says is, first of all, what he said, I will read this from Mr. Grossman's memo to the task force. It is clear that the commissioners, the ethics commissioners, still hadn't recognized that there are differences between 1, sunshine complaints filed directly with ethics, 2, SOTF referrals for enforcement, and 3, adjudications of charges / findings of official misconduct. Although John St. Croix, the executive director of the Ethics Commission, reluctantly agreed that he and his staff would work on a separate set, he said they would tweak the current draft to incorporate some changes with respect to the SOTF referrals and resubmit it, along with some non-sunshine changes that had been taken up. In any case, and I'm continuing here to quote Mr. Grossman, I strongly believe that the SOTF as a body should take some position on how the Ethics Commission should handle each of the 3 ways sunshine issues come to ethics: direct complaints, SOTF enforcement referrals, and official misconduct findings. If the task force doesn't do this, there will be some half-baked inappropriate provisions in the revised regulations rather than a clear and legally sufficient set of procedures for dealing with these 3 distinct ways in which violations of the open government laws reach the Ethics Commission. So what we need to do then, each of us, is to go over the proposed regulations and come up with some recommendations of our own on how the commission should handle these sunshine matters. I am not prepared here to offer any specific proposals of my own. Perhaps some other members of the task force will be, but this should at least get our mental juices flowing in that direction.
When's the next hearing? Does anybody know when this will be heard?
This will be heard at Ethics June 8th.
At what time do they meet?
I believe they meet at 5:30 p.m.
Do we know what day that is of the week?
Monday.
June 8th will be, I believe, on a Monday.
Are there any other comments?
No.
I just want, as a matter of public record, I wanted to thank Mr. Grossman for doing a detailed memo on the situation and doing his best to alert these members about it and to encourage our participation. I thought it was very helpful.
If there's nothing else, I guess we should move on. I think I can be there. So.
I think you have to be careful that you don't commit a seriatim meeting before you individually go up and speak your mind. I think that, less than a quorum can. Yeah.
Well, I guess that's an excellent point because, the question is, would we be speaking on something that was within the jurisdiction of the task force? Now, something within the jurisdiction of the task force could be making recommendations to Ethics Commission on the regulations. That said, I think that if people appear as individuals with suggestions to the body I don't think that's a violation. In fact, I think there's an explicit provision within the Brown Act and within the Sunshine Ordinance that says
You can.
any member can speak at another body's duly noticed meeting. The danger would be if people send emails amongst ourselves about, well, this is my position, and they seem to have a conversation that is not open to the public. So I think that to the extent that any one of us wants to appear and speak on these issues in our individual capacities or, on behalf of ourselves, not on behalf of the task force or a particular body, that's fine.
I think you guys could also speak as long as you're not a majority and you don't comprise a majority of a committee. If you know what I mean.
No, but say if Member Nee and I both show up and both speak, that's not a violation.
As long as you didn't speak before
Right.
about it.
Yes, that's true.
Yeah. So, I plan to attend, and by then we'll have read all the information and contribute hopefully to the conversation. But I don't think there's a violation as long as we're not communicating about it or trying to convey our opinions about it to each other. So we should be cognizant of that.
And I asked a question on that note. I actually read through it. I have some kind of half-baked ideas that I want to think through more, but I'm going to be out of town on the 8th. So what's kind of legally the best way for me to forward on my opinion to somebody who might be able to present it? How does that work?
There's not a really good way to do that.
Well, then again, you are not a voting member of this body.
Right.
What I would suggest is the following. I would suggest that you put your comments and questions in an email and you send it to Chris. Chris can circulate it to the members of this body, and you can have that in the public record. That would be it would be in the public records communications file. I believe as a ex officio, that's probably legitimate. That's what.
Yeah, because you're not
a voting member.
You're not a voter, so you're not trying to convince them to vote your position because you don't have a voting.
Right. What you need to be
you want to
aware.
get it to the task. You want to get it to the ethics commission. That's where you want to get the information to.
Well, I would leave it up to you. If it's something that you feel you want to submit directly to ethics, you can do so. If it's something that you would want to have one of us convey to ethics, then you can do what I suggested, which is to basically, here are my questions, here are my concerns. The thing we have to be careful of is not to. The one thing that could get us into trouble, I'm not suggesting anyone would do this, is if you became an intermediary, right? If you were like saying, here's what I think, what do you think? Member Chu.
Member so-and-so thinks this.
Member Washburn, Member Chu thinks this. And that's not what I hear you saying. What I hear you saying is you have some concerns that you think, or some issues or comments or suggestions, and you would want to see them raised.
Right.
So I think that is a different issue.
That can just be an email to the body. Not as a discussion.
Right, and I would suggest that it could also go in the public correspondence file or log, so that there's a clear record of what you said and to whom.
Okay.
Just for information purposes, the draft of the proposed new regulations can be found in today's packet, starting on page 167 and going through page 173.
Okay. Thank you. Chris, can you send everyone an announcement of that meeting and confirm the date and time and place of the Ethics Commission meeting? Appreciate it. Number 15 is the Complaint Committee report.
Everything in the report is accurate except for the roll call. Excused was Goldman, Member Goldman, not Member Johnson. Member Johnson was there dutifully and voting. Other than that, it is a correct account of what happened.
Thank you. Any comments? Seeing no public, let's move on to 16. Report Education EOT.
Yes, I'm reporting for Chairperson Sue Kaufman. First, she wanted to let the committee know that on May the 14th, the meeting had to be held in 2 different hearing rooms because the Assessment Appeals Board was still in session when we arrived. And after an hour in room 408, we had to vacate this room, which was locked down. We couldn't get to the bathroom. We couldn't get to anything. And then after an hour, they found us another meeting place. So she wanted to be ensured that our administrator be sure that we have a regular meeting place so we won't be inconvenient with, like we were the last time. And I just want to say that we really have a good EOT team this time. On the 14th, the meeting was heard from T.J. Lee of the Health Department, Shantae Program, and Joseph Shaw of the PUC Commission, and is working with them to improve their responses to sunshine requests. We're going to meet with them and train them. The committee is set for a presentation on the Sunshine Ordinance at Shantae's on June the 22nd meeting in response to complaint by Stephen Lawrence and Save Our Richmond Environment. The PUC has revived and upgraded its citizens access policies. The EOTC members will evaluate the new process at its June meeting. I would like to say that Member Allison is working with Sue on the new brochure. They're reviving it all, making it plain, where, cutting it down where the layman can really understand it. And, so we are really at work. Now, I also want to commend Mr. Doyle. He has really gotten in here, and he has really brought new energy to the outreach. He brought a presenter. I don't remember her name, but she was in the marketing business, and she was willing to, she came in here and told us that what she could do for us on a free basis with outreach by making cards and things like that. And I think that we have really gotten on a roll, and I think I've been on this board since 2000, and this is the best outreach team that I've seen, that we're all in a line with each other. All of us believe in training, and we believe in outreach. We really believe in outreach, telling the people, that's to the departments and to the residents. And I want to just turn it over to you so that you can tell us about the young lady that you brought. She was just excellent.
Her name is Brittany Tennell. I believe she's the president of YBR Productions. I'll be working with her to present a model to EOT in a little while on how perhaps we can bring on interns and other volunteer groups and converge just awareness first. And because you don't want to override too much with everybody, she's willing to be a political consultant for a while and set us up to make our model work, because she's been doing this for so long. She also presented a lot of good ideas about how to get pro bono, because we have no money. About Green, Soy Inc., and other agencies that are willing to get involved politically. To sort of what's beneficial for all companies involved, including getting involved with open government, and also hitting a different demographic that's lower, and really being touching on also what we've all been going on the merry-go-round about is email, and helping to do that too, and newsletters, and not just to the public, but to departments also. So that's a process that we'll be working on.
And just to make note, we have begun to look out at the audience, and when we make our determinations, whether it's violence, it's a violation or non-violation, we have begun to watch them and to see if they really understand. And Sue and I and Mr. Doral has really, if they don't understand, we catch them in the hall and say, do you understand what has really happened and what's going on? So we're trying to make our outreach really good. And what James just said, we need to build a good relationship with the actives. This has been going on for years and years, and so maybe that's something we could do too. We all seem to have humble spirits here, and we all have to work together, and we don't want to be divided. And like you said, maybe we can be that cohesion and that catalyst to work with the ethics committee, that we've had so much trouble with so long. I don't think they're bad people. It's just sometimes people it's not important to them, and they just let it stay down.
I would also like to add for the baby steps comment before. I believe that sometimes it's not about the win.
Mm-hmm.
Sometimes it's just about what's fighting for. So if it goes forward enough and enough and enough and enough, then finally something maybe may get done.
Yes, we're hoping.
And that's the end of our report. Thank you.
Thank you. Any other comments? Complaints and amendments?
The draft minutes reflect accurately the proceedings of our May 12th meeting. Just a couple of things. The summary of sections 3 and 4 of the amendments, summary and footnoting, is still a work in progress, as is the drafting of electronic record retention guidelines for this task force, particularly emails.
Thank you. Any other comments?
Member the invitation to Frank Darby and Ron Vinson. Do you want me to send out that invitation, or would you want to do it like you did the last time?
I'm not clear on your question.
The committee had invited Mr. Darby and Ron Vinson of the Department of Technology to discuss the email ordinance administrator's email box.
Yes, please. Please tell both of them that they are encouraged to attend. Their attendance would be appreciated.
Okay. Thank you, Madam Chair.
Okay, administrator's report.
We have right now 3 complaints coming before the complaint committee, and that could push it a little bit beyond the 4 o'clock deadline. So if CAC could be indulgent, patient.
Well, you think I can wrap that up in a half hour?
Yeah, really.
He's the king of the lightning hearing.
Really?
No insult intended.
We'll get it done.
Half the time we
It wasn't
we get it done
malicious
before
also.
everybody's there.
Excellent.
That concludes my report.
Thank you. Announcements, comments, questions, and future agenda items from the task force. Seeing none, we are adjourned.